which is Tuesday, April 19th, 2022. This is the hearing for Deschutes County file numbers 247-21, 001043 PA, and 1044-ZC. This is for a comprehensive plan amendment and a zone change request. The applicant has requested approval of the comp plan amendment to change the designation of the properties. Can you not hear me very well? Let's pick up my voice here. To change the designations of the properties from agricultural to rural residential exception area, RREA. The applicant also requests approval of a corresponding zone change to rezone the properties from exclusive farm use, EFU, to rural residential 10-acre minimum, RR10. I didn't mention my name, Stephanie Marshall, and I am the hearings officer in this matter. We're holding the hearing in part through electronic means. So before we turn to the particulars of the hearing, I'm going to turn things over to Ms. King to describe how the electronic process works.
Thank you, Hearings Officer Marshall. Good evening, everyone. For the record, my name is Hallie King, and I'm an Associate Planner with Deschutes County Planning Division. As Hearings Officer Marshall noted, the item before us this evening is a comprehensive plan amendment and zone change application. I want to make sure everyone can first see my screen here. Okay. I'll begin the hearing by providing instructions on how the hearing will be conducted and how members of the public can testify. Then I will turn the hearing back over to Hearings Officer Marshall for her hearing instructions. I will then follow with my brief oral staff report. The applicant will then have an opportunity to make their presentation and present their testimony and evidence. Then interested persons will have the opportunity to provide testimony, both in person and remote. The applicant will then have an opportunity to present rebuttal testimony. And last, staff will be afforded an opportunity to make any closing comments. As mentioned, tonight's hearing has a hybrid format allowing both in-person and remote participation. I do want to note if the county's internet connection should be interrupted for any reason, we will attempt to get back online as soon as possible. If this happens, please give us a couple of minutes to reactivate the public hearing before you attempt to link or call back in. If your own connection gets interrupted, please attempt to join back using the same number or link that you used initially. For those attending via Zoom, there are two levels of participants, an attendee or a panelist. As an attendee, your video will not currently be active and the county's producers controlling your microphone. As a panelist, your microphone and video will be active for everyone to hear and see you. This is an important distinction because anyone wishing to testify tonight via Zoom will be promoted to a panelist so that their audio and video can be recorded for the record. I'll go over some of these functions in just a few moments, but first I would like to address the folks that we have here in person tonight. For everyone joining us in person, once we are at that point in the public hearing, the hearings officer will ask you to raise your hand and invite you up to the front table here to provide your testimony. There is a sign-in sheet at the front table that we would ask you to please fill out your name, mailing address for the record. And I'll also be reminding folks to also state their name, mailing address for the record as well. A couple tips for those attending via Zoom. As a panelist, first is going to be the microphone button, which will be on the bottom left-hand side of your screen. Once you're promoted to a panelist, you will need to unmute to state your name and provide your testimony. Also, I want to point this out because if you would like to confer with your legal counsel or others in the room, that mute button will be important. As long as you're unmuted, your conversation will be recorded for the record. To the right of the microphone button is one for the video. Again, as long as you're sharing your video, that will be recorded for the record. The last feature to explain here is the raise hand function, which this will be referenced and used a couple times throughout the hearing tonight. This will be the way that you get the attention of us here that are in person if you would like to provide testimony. So please take note of that button. For anyone attending via phone, there's a couple of another important tools to note. *6 is going to be the button you'll push to mute or unmute your voice on your phone call. And to raise your hand, again, if you're calling in from your phone, you will enter *9. All right, so at this time, I'm going to take note of everyone attending via Zoom who wishes to testify. So what we will do is we will ask those folks wishing to testify on Zoom to please select the raise hand feature now. And I'll go through each person who's raised their hand, and I'll ask the producer to elevate you, and we will ask for your name, first and last name, mailing address, and if you will be testifying in support, opposition, or neutral to the subject application. Again, if you're calling in from your phone, you will want to enter *9 to raise your hand. And please bear with us, this may take a couple minutes. We've got a lot of folks here, so I want to make sure we get everyone written down who wishes to testify. Ryder, if you could please state your name, your mailing address, and if you're testifying in support, opposition, or neutral.
My name is Ryder Redfield. My mailing address is 8801 Northwest 93rd Lane, Terrebonne, Oregon 97760, and I am in opposition.
Thank you, Ryder. Oh, Ken, if you'd please, and Ken, just to note, Ken is the legal counsel for the applicant.
Excuse me.
Yeah, Kim Katzeroff for the record, counsel for the applicant, attorney at Schwab, Williamson and Wyatt, and my address is 1420 5th Avenue, Suite 3400, Seattle, Washington 98101.
Thank you, Ken.
Thank you.
Next is Becky Powell. Becky, if you could please, you may have to unmute.
Okay, hi, I'm testifying in opposition, but I've sent in a letter, so I just have a few comments to make.
Thanks, Becky. Could you please provide your mailing address for the record?
20607 Coventry Circle, Bend, 02.
Thank you, Becky. Scott Hayes.
Hi, good evening. Scott Hayes, 10135 Northwest Coiner Avenue, Redmond, Oregon, and in opposition.
Thank you, Scott. Dell Johnson, if you could please state your name, mailing address, and if you're in support, opposition, or neutral. And Dell, you may have to unmute. Dell, it looks like we aren't able to hear you. I think you're still muted. On the bottom left, you'll see the microphone button. Okay. Oh, I think, hey, Dell, can you hear us? It looks like you may be unmuted now, but we can't seem to hear you. Next to your unmute button, there is a tiny little arrow which you can expand to confirm your audio settings. That may help to make sure you're talking through your computer microphone. Yeah. Let's go. Okay, Del, we'll come back to you in just a minute. Nunzi, if you can hear us, please state your name, mailing address, and if you're in support, opposition, or neutral.
Hi, Nunzi Gould, 19845 J.W. Brown Road, Bend, 97703, and I'm in opposition.
Thank you, Nunzi. Chris, if you can hear us, you state your name, address, and support, opposition, or neutral.
Yes, my name is Chris Clemo. My mailing address is 2237 Northwest Torrey Pines Drive, Bend, Oregon 97703. And I am the applicant's transportation engineer and will be testifying in support if called upon.
Thank you, Chris. Mark, can you, if you...
Yeah, can you hear me?
Yes, we can hear you.
Great. My name is Mark Stockcamp. Mailing address is P.O. Box 1345, Sisters, Oregon, 97759, and speaking as the applicant in support.
Thank you, Mark. Oh, I think we got Becky already. Yeah. Looks like Pam. Yep. Pam, if you could please state your name, mailing address, and if you're testifying in support, opposition, or neutral. Pam, please make sure to unmute there on the bottom left hand corner of your screen.
Pam Mayo Phillips, 21199 Northwest Spruce, Redmond, Oregon. I am in opposition. I did submit a letter and would like to leave comments.
Pam, could you state your zip code for the record?
97756.
Thank you. Paul, if you would please state your name, mailing address, and if you're testifying in support, opposition, or neutral.
My name is Paul Lipscomb. My address is P.O. Box 579, Sisters, Oregon, 97759. I am in opposition, and I have submitted written testimony, but I may wish to speak depending on what the applicant says tonight.
Thank you, Paul. Dale, you're now elevated to panelist. If you please state your name, mailing address, and if you're in support, opposition, or neutral.
My name is Dale Stockcamp, and my mailing address is P.O. Box 1345, Sisters, Oregon, 97759. and I am applicant in support.
Thank you, Dale. Brian, you should now be unmuted.
Yes, I am. This is Brian Rabe, R-A-B-E, with Valley Science and Engineering, and I am the soil scientist on behalf of the applicant.
Brian, could you please state your mailing address?
Yes, thank you. 3511 Pacific Boulevard, Southwest, Albany, Oregon, 97321.
Thank you, Brian. Robin, if you could please state your name, mailing address, and if you are testifying in support, opposition, or neutral.
Robin Vora, 1679 Northeast Daphne Court, Bend, Oregon, 97701. A statement in opposition.
Thank you, Robin. Tim, you're now elevated to a panelist. If you could unmute and please state your name, mailing address, and if you're in support, opposition, or neutral to the application.
Tim Phillips. I am in opposition. Address is 21199 Northwest Spruce Avenue, Redmond, 97756.
Thank you, Tim. Del, we've elevated you now to panelist. If you want to try to unmute again, to state your name and mailing address, and if you're in support, opposition, or neutral. Del, it looks like you're unmuted, but we can't hear you. Del, if we'll give you another few minutes here, but what you can also do is email any comments to me, and I'll give my email address during our presentation, and we can put those into the record. But we could also try you again once we're at the testimony portion to see if we can get your audio to work. Okay, it looks like we've got 3 phone calls. Again, if anyone, just checking 3 folks that are calling in, if you would like to provide testimony, again, please select *9 on your phone. Give you a minute to make sure. Okay. I don't see any. Looks like, yeah, everyone wishing to testify remotely has put their name on the list. So we'll move ahead here. I'm going to go back to my presentation. Okay, so moving forward, so for as far as the order of testimony goes, the applicant will provide evidence and testimony first, and then we will go to anyone who will be in support of the applicant's request. First, we'll have remote participants who have put their name on the list go first, and then anyone in person. Then we will go to folks that are wishing to testify in opposition. Again, remote will be first, in person second. And anyone neutral to the applicant's request, which I don't have any that would wish to testify remotely, but again, if there's anyone in person wishing to testify neutral, we'll have them go next. And then the applicant will have an opportunity for any rebuttal testimony. With respect to oral testimony this evening, Hearings Officer Marshall and I are responsible for ensuring a respectful and orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. In addition to oral testimony, if anyone has written testimony to submit, please provide that directly to me. If you're in person, you can submit that prior to beginning your testimony or at the conclusion of the hearing. If you would like to participate, if you're participating remotely and have any written testimony, that should be emailed to me. My email is here on the screen, hallie.king@deschutes.org. I do want to remind folks that if your submittal is more than 20 pages in length, includes color figures or documents which should be printed larger than 8.5 by 11, you will need to submit that testimony both electronically and as a hard copy. At this time, I'm going to ask if there are any objections to the format of the hearing that we've reviewed thus far. If yes, please raise your hand if you are here in person, or use the raised hand function if you are attending remotely. Okay. Dell's raising his hand. Okay. Stephanie, will you try to elevate him again? Yeah. Looks like Dell, you've got your hand raised. We're going to try to elevate you again to panelists to see if we can hear you. Okay. Dell, you're now elevated to panelist. Again, if you're able to unmute. Dell, we're not. You look unmuted, and I don't think we're not hearing you. Yeah. Okay. Dell, we'll have you if you can submit testimony. Any additional comments that you have, we'll make sure those will get uploaded to the record. Sorry if you're having technical issues. Kelsey, okay, we have one more. Kelsey will elevate you to panelist. Kelsey, you may need to unmute your microphone there on the left-hand side of your screen.
Hi, I'm Kelsey Nonella. I submitted a letter of opposition and may want to comment depending on what is said.
Thanks, Kelsey. If you could also please state your mailing address for the record.
Yes, my mailing address is 10611 Northwest Kingwood Drive, Redmond, Oregon, 97756.
Oh, Kelsey, could you spell your last name too? Sorry.
Nonella.
Perfect. Thanks, Kelsey. All right, so it looks like no one here has objected to the hearing format. So with that, I will turn it over to Hearings Officer Marshall.
Okay. Thank you. Again, my name is Stephanie Marshall, and I am the hearings officer assigned to this matter this evening. This is a quasi-judicial hearing. My review will be on the record, and I take note of the record that's been developed up to this evening. And of course, if anything is submitted this evening and oral testimony, that will become part of the record. And at the conclusion of the hearing, we'll discuss whether there's a request to leave the record open for a specified period of time. And along those lines, if there is something that you wish me to consider, factual evidence or legal arguments, we have a raise it or waive it rule, which is if you don't bring it up, then I can't decide on that basis. That's fairly obvious. But if in the future, at a different level of appeals, you want to raise a new argument, that reviewing body will not allow you to do so. So I encourage everyone to be thorough. There was also a question at the beginning of the hearing whether I set time limitations on testimony. I typically do not, but I do ask that everybody be mindful of repetitive testimony. And if you have submitted a letter into the record, I will review every letter. I prefer that you hit the highlights, or as several panelists have noted, if something comes up this evening that they had not heard before, certainly you may, and I encourage you to comment on that. But please don't read your letter or your email into the record because it's already part of the record. So I appreciate your attention to that. And also please silence cell phones. I have a few preliminary items to address. The first is that I want to disclose that I have had no ex parte contact outside of this hearing. Ex parte means anyone that's interested in or against the application having a discussion with me before the hearing. The only contact I've had regarding this matter is review of the staff report and scheduling the hearing, and reviewing the preliminary opening statements. So I've had no ex parte contact, and I also have no interest in the land that is the subject of the application, nor in the applicant themselves, and I believe that I can conduct this hearing in a fair and impartial manner. So at this time, I will ask if there are any objections to my hearing this matter this evening, and I'll leave extra time for those participating via Zoom to raise their hands if they so wish. Okay. Thank you, everybody. Okay, so the applicant has the burden of proof of establishing that they are entitled to the request that they've made. And there are two requests, the comprehensive plan amendment and the corresponding zone change. The standards that I'm reviewing are set forth in the staff report, and there is a copy over there, a stack of copies actually, by the door. So if you'd like to be able to refer to those standards, that would be great. Of course, I will hear testimony that don't directly relate to these standards if you believe that other standards should apply that are not addressed in the staff report. Testimony and evidence should be directed towards the approval criteria or any other criteria, as I just mentioned, in the comprehensive plan of the county or land use regulations. All right, I've already talked about the raise it or waive it rule. If you want something to come before me, factual or legal, please raise it with sufficient specificity so that not only I can understand your argument, but anyone else responding to that will also be able to do the same. If this was to be appealed to the Land Use Board of Appeals, you need to be able to establish that you raised that issue to me. And I believe Haley has gone, oh, I'm so sorry. Holly has gone over the order of presentation, and I've mentioned that the record is before me and will be added to this evening via this hearing. One last matter, continuances. And I mentioned this earlier. The grant of a continuance or record extension shall be at my discretion. And if I do grant a continuance, the hearing will be continued to a date certain. That means a continuation of this actual hearing. And the other and/or leaving the record open for additional written evidence or testimony. Typically, that's a 7-7-7, so 7 days for submission of new evidence, 7 days for rebuttal of that evidence, and then a final 7 days only for the applicant to submit final legal written argument. And then I think that I've covered everything. So I will go ahead and turn it back over to Holly, and thank you all for being here this evening.
Thank you, Hearings Officer Marshall. I will now present my brief oral staff report. Get my... All right, so as discussed, the application request tonight includes a comprehensive plan amendment and zone change request for the subject property shown here on the screen. The subject property totals approximately 710 acres. The property is about 2.2 miles north of Highway 126. The southern boundary of the property is located at the western terminus of Northwest Coiner Avenue and located to the southeast of the Lower Bridge Way and Buckhorn Road intersection. The Lower Bridge Estates residential subdivision is also located to the northeast of the subject property. The comprehensive plan amendment request includes the request to change the designation of the property from agriculture to rural residential exception area, as well as a concurrent zone change from exclusive farm use to rural residential 10 acre. The applicant is not seeking an exception to Goal 3, which is related to agricultural lands, but rather seeks to demonstrate that the subject property does not meet the state definition of agricultural land. The applicant has provided a soil study performed by Valley Science and Engineering, which asserts that the property contains predominantly Class 7 and 8 soils. Furthermore, the applicant has included a traffic study prepared by Clemo Associates, which is referenced in the staff report and included in the application record. Staff would like to note that a number of public comments have been submitted to the record, both in response to the notice of application as well as the notice of public hearing. I've briefly summarized some common themes to the best of my ability here, but please refer to the application record, which includes public comments in their entirety. Those in opposition of the application cite concerns with traffic, water supply, impacts to farming and agricultural land, impacts to wildlife habitat, and growth management concerns. Those in support of the application reference the property's unproductive soils, invasive tree species removal, potential for expanded road access and protection from wildfire, and the expansion of rural housing opportunities. I do want to highlight a few items which have been included in the record after the release of the staff report. The first is a memo to the hearings officer from staff correcting 2 comprehensive plan policy references. Staff inadvertently left out some text in the staff report, and the memo addresses the correct text as well. Second, I do want to point out we have received just over 100 public comments since the release of the staff report on April 12th. We've done our best to get those uploaded to the record as they've come in. We also received an agency comment today from the Department of Land Conservation and Development in conjunction with Department of Agriculture and Fish and Wildlife regarding the subject application and asserting that the property could qualify as resource land. And again, this is all included in the record. The applicant has also provided some late record additions. On April 18th, they submitted a groundwater use evaluation report prepared by GSI Solutions, and the applicant's attorney has submitted a response letter to public and agency comments, as well as some supporting documentation. This has also been uploaded to the record in its entirety. Again, I do want to note staff aims to upload documents received as quickly as possible. I've been checking email and we've gotten some additional comments in late this afternoon. And as of 4 p.m. today, everything has been uploaded to the record, but anything received after 4 will be uploaded as soon as possible. And with that, that concludes my oral staff report. We are available for questions from the hearings officer, should she have any.
Okay. Thank you very much. I do not have any questions at this time, but would like to begin with the applicant and his representatives.
Hi, good evening. The video function has been apparently disabled, so I'm hoping we can get that fixed real quick before I start.
Let's see. Yeah, we'll work on that, Ken. Let's see, I think. Okay, Ken, try it now. There we go. We can see your.
There we go, although I don't see myself, which is bizarre. So 1 second. I apologize. There we go.
Right.
Made it. Hi again, for the record, Ken Katzroff. I'm an attorney at Schwab Williamson & Wyatt, as my lovely background says. And I'm here on behalf of the applicant. Also again, for the record, 1420 Fifth Avenue, Suite 3400, Seattle, Washington, 98101. Before I give my presentation, the applicant would like to address the hearings officer as well as everybody else in attendance today. So if you could raise Mark Stockcamp, and I'm going to turn off my video and mute, but just for the ease of time, if we wouldn't demote me. Also, I will note that Mark has a number of other folks, as well as Dale Stockcamp. And Mark has a number of other folks who are principals of the applicant with him, who are also planning to give brief statements, and they will introduce themselves and provide their addresses at that time. Thank you.
Thank you.
Hi.
Hi.
Can you hear me?
Yes, I can. Everyone else in the room, can you hear all right? Okay, good.
Okay, thank you. I'm Dale Stockcamp, and I have owned a home in Deschutes County for 26 years. And for the record, my mailing address is P.O. Box 1345, Sisters, Oregon 97759. And while tonight's hearing and subsequent follow-up is going to focus on technical and legal aspects such as soil quality and whether this subject property has agricultural value, I thought it's important to introduce the team behind 710 Properties and share some thoughts about our motivations and heart about what we're trying to do here. For us, our motivation is that we want to share this incredibly beautiful property with others. We want it to go beyond just having one household that benefits from living here and is currently on this site to share it with others. But we want to do it in a way that strikes a balance between the need for more rural residential housing options, but also considers the impact on nature as well. My colleagues and I have been greatly blessed with successful businesses earlier in our careers. And because of that success we've experienced, this project is really not about maximizing profits. If we were trying to maximize profits, we would be doing things quite differently. First, we'd be pursuing higher housing density than the rural residential 10-acre zoning that we're currently applying for. And we may even explore destination resort, since that current overlay provides for that option. That's not what we're wanting to do, though. We're wanting to try to maintain a balance between rural residential and nature. And if we were worried about maximizing profits, even though this subject property is not covered by a wildlife combining zone or what others might call a wildlife overlay, we would not have early on engaged one of Central Oregon's leading environmental wildlife experts to guide us in the design and practices, which include things like corridors, vegetation, and other recommendations, all which will require funding of some sort or another to guide us on how to design and really develop this property that would maintain a healthy environment for wildlife. If we were concerned mostly with profits, we also would not be pursuing additional expenditures associated with developing a community that utilizes sustainable energy, such as solar power, which we're looking at to predominantly power the area. But most important, and I think the thing that you need to understand what motivates us, is if we were trying to maximize profit, we would not be doing what we're doing, in that we are committing the first and significant proceeds from the efforts that we're undergoing here to serve the broader Redmond, Bend, Sisters, and Deschutes County community. Particular causes that are close to our hearts include homelessness, housing affordability, rent assistance, youth development, and other social services that serve the hurting and disadvantaged. We want this community that we hope to be approved and we hope to be able to build to benefit not just the homeowners that are fortunate enough to live in this area, but the broader Deschutes community as well, especially to be helping those that are struggling. And sharing our resources and giving back is something that members of our team have been doing for many, many years. So beyond the technical and legal aspects of our zone change application, we thought it was important that people meet and understand more about the Central Oregon team that's behind 710 Properties. And with that, I'll turn it over to my colleague, Robert Turner.
Thank you.
Hallie, could you please elevate Mark Stockamp? And I believe Robert Turner will be testifying from that same screen. And if you would like, you can demote Dale. Not that you're really demoting you, but.
Mark is now elevated.
Hi, I'm Robert Turner. I currently reside in Sisters, and my mailing address is P.O. Box 1345, Sisters, Oregon 97759. Hi, I'm Robert Turner, and I have lived in Deschutes County for 53 years. And a lot of us growing up in a rural residential property in the Pine area. Having the opportunity to live in a rural residential area is an attractive feature of living in Deschutes County that is becoming extremely hard to come by. We are hoping to be allowed to provide a limited opportunity for others to share the rural lifestyle that I grew up with on the property that is not suited for farm use and that is removed from other farm uses by significant terrain changes. And the property has steep cliffs that raise the plateau above the actual farmland by more than 200 feet. My colleague, Charles Thomas, would like to share his experience living on the subject property that we are discussing today.
My name is Charles Thomas. And for the record, my mailing address is P.O. Box 1345, Sisters, Oregon 97759. I've been a Deschutes County property owner for decades, and I currently enjoy living in our off-grid home, which is situated on the subject property. We are solely powered by solar generation. Robert and I have consulted with several experts to better understand the facts about this property. And this property, which sits on a plateau north of Klein Buttes, Buckhorn OHV trail system, consists predominantly of rock and juniper. We have brought in our colleague Mark Stockamp to compile the facts and data collected by the experts and to begin planning a rural residential community that respects its setting, and which Mark will now share.
Thank you.
All right. Last one here. So, hi, my name is Mark Stockamp. I currently reside on rural residential land in Deschutes River Woods, and my mailing address is P.O. Box 1345, Sisters, Oregon. My colleagues and I, we've been incredibly proactive in our approach to better understand this land. We have a slide in it that Ken's going to share coming up here, but I thought it's important for us to share just the list of leading experts that we brought in to conduct extensive research on the subject property we're discussing. For soil, we brought in Brian Ravey, who has over 35 years of experience. For wildlife patterns, we brought in Dr. Wendy Winnie, who is widely used by Deschutes County, and she has 15 years of experience. For traffic impacts, we brought in Chris Clemo with 30 years of experience. For water use, Ken Light, who's got 30 years of experience. And then as well for fire prevention, we brought in Craig Letts, and he's got 30 years of experience as well. If this application is to be approved, we're going to be listening to public comments provided throughout this process, and our goal is to develop a low-impact subdivision compatible with rural living, including the wildlife. The primary purpose of tonight's hearing, however, is to determine if the soil on this land is farmable and if it benefits if it merits protection for future agricultural use. Our team can say with absolute certainty that this land is not farmable, and I'm going to pass it over to Ken to explain why.
Okay, thank you, Mark.
All right, I'm back. I appreciate the team, and I just have to say, before I start with my comments, I wanted to thank staff. I meant to do that before we started our comment at all. I will say that Hallie has done really a remarkable job of communicating and managing the large amount of comments that have come in. We very much appreciate on cases like this having things uploaded to Acela very quickly, and she's done that, and that's just really rock star. So I really very much appreciate it, and I want to say that now before I forget. So the second thing I want to say is that, when we do hearings like this, I don't often go through that kind of litany of having the applicant actually provide some initial comments. And I think it's important here because it's not often that I have a land use client who, quite frankly, really has taken the time to understand the subject property and is trying to do what they can to best move it forward. When quite frankly, they're willing to put the money where their mouth is and understand it and how to make the best development pattern and how to work with the environment. I think that's really cool. And it makes the process a little bit more fun for me. So that said, I'm going to try to share my screen, assuming I can get that to work, and provide a few short comments, or at least as short as I possibly can, because we have already obviously submitted comments to the record as well as the application, and that is really what is necessary. All right, can you see my screen okay?
Yes.
All right, can't believe that worked. That's great. All right, so again, we're here for the plan amendment and zone change. I'm not going to reference the file numbers, etc. We've already met all of these people, so don't need to dwell here. As Mark stated, this is kind of I'll just call it our bench strength when it comes to the experts that we've engaged to work on this zone change. And again, to be clear, the proposal before the county at this time is only for the zone change and plan amendment. There's not a specific development proposal before the county at this particular point in time. Next is I want to set the table a little bit for where exactly we are. And staff previously showed a picture, but this is, I think, super helpful. What you can see here is that we've got a large plateau area that has some rural residential use on the north end of it. And then significant cliffs on I'll just call it the northwest and southeast that separate it from additional uses. What you can also see is there's an area in white here that used to be a surface mine and was a similar sized property in that it was over 500 acres and was also rezoned rural residential 10. You also have the property is north and east of BLM's off-road vehicle recreation area for Cline Buttes. And that's important because that area has already been designated for vehicle recreational use. Next slide. Also important is to kind of understand where we are on the zoning picture here and what the actual uses that are permitted in the area. What I've tried to do here is show a real good snapshot of a broad area. And what you can see on the bottom right of this is where the Redmond urban growth boundary is. And as it moves out to the north and to the west, you have a mix of rural residential exception lands and rural residential zoning. And that takes the form of really the MUA 10 zone and the RR 10 zone, which is what we're asking to rezone the property for. What you'll also note is there are several areas that have been specifically overlaid with Deschutes County's destination resort map. I am not saying, as you heard Dale say earlier, that we are coming in for a destination resort. What I'm saying is that it's important to understand that the county has already looked at development on this property and what could be permitted and what could be allowed. And under ORS 197455, there's a list of specific criteria for citing a destination resort, and it meets it. And I would submit that those criteria are quite stringent. But again, we are not asking for that, and it would not be a requirement to have this rezone or comprehensive plan in order to do that. We could do it today if we wanted to do that application. Again, we do not. What's important of this application and why it may be relevant is that rezoning this property to rural residential would preclude effectively an establishment of a destination resort in the future. And that would be because presumably a rezone to a rural residential 10 would lead to a rural residential subdivision. It's highly unlikely, at least in the medium or long term, that anybody would come back and say, hey, not only do we have a subdivision, but now we're going to try to get rid of that subdivision and instead do a DR. It just doesn't make much sense. So I throw that out there only because it's relevant that the planning process that we're going through now would effectively preclude that use being established. So now that I've set the table with kind of where we are in the zoning, I want to kind of set the table on what the law is. And what we're here today is to really look at how we meet the criteria for this rezone and comprehensive plan amendment. And so I'm going to start in the comprehensive plan itself. Section 2.2 is the agricultural lands policies, and goal 1 of that is to preserve and maintain agricultural lands and the agricultural industry. However, policy 2.23 specifically says that we should allow rezones for lands that do not qualify as resource lands. And we're going to talk about that a lot more, well, briefly more. What this really looks like, in effect, is also implementing the rural residential housing policies of Deschutes County. And this is implemented through the exact process that we're here to do today, to look at the subject property and to demonstrate that it does not meet the definition for agricultural or forest land, or to take an exception. We're not taking an exception. We are just proving that we do not meet agricultural or forest lands at this particular point in time. So how do we do that? Well, we have to show that we do not meet the ag land and that we do not meet forest land tests. And we simply don't meet the definition of either. And for ag land, it's that we have really, really bad soils. It's just rock. And for forest land, there are no forest soils for the NRCS's soil survey and no merchantable timber. We've also submitted some additional information to the record today on this specific point to show that there is no viable timberland on the subject property. So what we're really talking about here is the agricultural land designation and the soil study. So what does that really look like? Well, in Eastern Oregon, land is predominantly these soil types, class 1 through 6, are identified as ag land. We do not have that. On the subject property, we have significantly worse soils. Not really going to spend a lot of time on this slide, only to share what class 7 and 8 soils means, which is what we have here, 71% of the soils on the subject property. And that means they have severe limitations that make them unsuitable for cultivation. Or class 8 is that they nearly preclude crop production. That's just really, really bad soil. So rather than look at a lot more text, picture's worth 1,000 words. So I'm going to show 1,000 pictures. No, I'm just kidding. I'm just going to show a few pictures here. And these pictures are taken in various locations throughout the subject property. This shows a portion of the property, a bunch of rocks, some junipers, certainly not good soils. Again, we've got a lot of lava rock that is just all over the property. Another picture. What you see here is very sparse ground cover, some junipers, and rock. I keep going. A lot more rock, a lot more juniper. The next picture shows us what sort of some of the edges of the property look like, and the ledges are just plain rock. And what you can see is that there's a steep decline up on the upper right-hand side, down and off the plateau. People are probably getting tired of rock, but I got some more to show you. Again, more rocks, very low cover, not a ton of forage for grazing or for wildlife, quite frankly, and more junipers. I promise you I'm almost done showing you pictures, but I just want to get this point through, which is there simply is not good soil on this property. We are more than 71% class 7 and class 8 soils. Okay. Now this picture is one of my favorites because this shows you the type of vision that this applicant has for the property. This is the existing home that's off the grid, and it shows how it can be harmonized with the rest of the subject property. The last picture I'm going to show you is of the northern area of the property, and it shows you a good contrast of the subject property and what actual farmland looks like. So the left-hand side of this picture shows an operating farm with irrigation water, which this property does not have, and soils that can actually cultivate crops. Okay. So beyond just the idea of whether or not you have decent soils, the question really goes into a goal 3 question, but whether or not the land is suitable for farm use. And the goal contemplates a number of different criteria, and we've addressed these in our burden of proof and in subsequent submittals, but I'm going to go through these really quick. Again, we have expert opinion that soil fertility, we have really bad soil. There's analysis on climate that we don't gain enough water or any other precipitation to make a viable run at farming. There is no irrigation on the property, and equally important, it would be cost prohibitive to try to purchase water rights from area farmers. And on this point, we've submitted additional information to the record, and I think it often gets confused, but let's be clear here. Farm use uses significantly more water, magnitudes more water than a rural residential or residential use. So maintaining the status as EFU or farm use zoning simply doesn't save water if you put it into actual farm use, which we can't do here. It's not what I'm saying. Lastly, we're looking at the land use pattern. I've already discussed the zoning, the checkerboard around it, and how it's gradually turning more into more rural residential, consistent with our request here, and then what it would take to actually make it suitable for farm use, which simply cannot do. There's been several comments in the record, as well as just questions asked about what about using the property for grazing. And that's something that I want to address, because in Oregon law, there is a specific definition for what farm use is. And it is the current employment of land for the primary purpose of obtaining a profit in money. And that's really important, because when we talk about what the legal standard is or the legal protection is for farm use, the use still has to qualify as a farm use. And that means it has to be engaged in the primary purpose of obtaining a profit of money, which means just because you have a horse on your property that you like to ride, or a single cow that you raise for yourself for meat, that is not a farm use. It does not meet the definition of such, and therefore it does not meet the standards for protection under state law. So on this particular property, if you were going to look at grazing, we've provided some analysis in the application, but I'm going to shorthand it here. Using the Oregon State University formula for how you can project income, the maximum amount of income potential on this property for 710 acres, if it was used for grazing, is, let's just say, $48,000. Put that aside and also consider whether or not there would be additional costs of labor, etc. The property taxes on the property alone this for the tax year 2020 were over $15,000. So your margin is getting very, very thin. But I think there's something that's really important to mention about this OSU formula, and that's that it assumes that if you are grazing on the property, that 100% of the forage that is grown on the property is actually eaten and taken by cattle in the grazing operation. And that simply doesn't make much sense. If they take 100% of what is grown on the property, there's nothing to grow the following year. And so we've provided some additional information about why the actual more likely scenario for grazing is about 25%. And so it's important to realize that this formula, even as inflated as that annual income may be, is really premised on a false assertion that you could graze 100% of the forage. So I just throw that out there. If we're also looking at what may be additional farming practices that could be made on the subject property, I need to hit that a little bit, which is it is not an accepted farming practice to try to irrigate Class 7 and Class 8 soils. That is confirmed in a decision by the Board of County Commissioners and should apply here. There hasn't been any identified accepted farm practices that could make this a productive farm. Again, there is no water, and residential use would use substantially less. Last note here, there's been some comments in the record about declining water levels. And again, a residential use significantly less water, but it's unlikely that a groundwater permit would be granted for an agricultural use in this area. It would simply, the basin is a closed basin and it requires one-for-one mitigation for new groundwater permit applications, and that's no easy task. All right, a couple of other quick points and I will wrap my topics up. One of the last considerations of whether or not this land could be used for farmland is whether or not it can be used in conjunction with other areas. As I've already mentioned in showing our zoning map, we have a lot of rural residential in the form of RR10 and MUA10 zoning surrounding the property. There are some other non-farm properties that have been approved for non-farm dwellings. And then we have a BLM property. But that property, as I've already said, is used for off-road vehicle recreation and cannot be put back into grazing at this time. It would require a new NEPA process and probably make a lot of folks angry to take that out of recreational use. And so there has been a question about whether or not you could graze this in conjunction with other properties. You simply cannot, not only because there aren't any surrounding properties, but it's really physically impossible. And that gets me to this slide. What this shows is the vertical change in between the subject property, which is in the middle portion, and the surrounding properties. There are steep cliffs that are as high as 250 feet different in a vertical, pretty much on surrounding sides that are not developed with rural residential uses. And so the idea that you may be able to range cattle or use it in conjunction with another property, it's simply not practical and couldn't be done. All right. Couple of last points, which are there has been some questions in other zone change applications about whether or not you can use a specific and more detailed soil study in order to show that land does not qualify as agricultural land. And the answer to that question is yes, you can. The goal specifically contemplates using more detailed soil studies than how the soil was originally mapped by the NRCS. And in fact, the law, ORS 215-211, specifically permits that. And so I don't think that that's really at issue anymore. It's a settled question that's provided directly on point law. Last thing I have is to show kind of a map of similar decisions. I had already referenced the 500 plus acres at Lower Bridge, but here's some of the similar processes or similar applications that have been approved for rural residential or MUA 10 zoning just recently, and many of them are large properties as well. So with that, I'm going to leave my favorite picture up for a moment and ask if the hearings officer has any questions. Otherwise, I will reserve time for potential rebuttal.
Okay. Thank you, Ken. I guess I did have one question, and it's kind of curiosity. In the pictures that you were showing with the rocks and all, and I honestly don't know this, and so I'm curious, and I'm going to open it up to anybody else that wants to maybe address it. As far as grazing, is it difficult, forage aside, is it difficult to have animals on the terrain as it is, or dangerous? Again, this is just something that popped into my head. I haven't heard this in any other hearing with similar or lands as what appears here. I just honestly don't know if the rocky conditions make it more difficult to graze, forage aside.
Yeah, so forage aside, I don't really have a good answer for you. What I can say is I do know that there are similar BLM type lands that are grazed. Whether or not that prevents or has an actual danger to animals, I can't answer that question. There may be people in the audience who have a better who could better address that, and certainly it's something we can address in post-hearing comment if the record is left open. Forage aside is a good question, though, because what the rocks are showing is we can't provide a lot of forage. And I wasn't going to talk about this now, but I think it's worth mentioning given that you asked the question. And Hallie highlighted that we do have a letter that was submitted today by DLCD, Oregon Department of Ag, and ODF&W. And in that letter, they actually agree, or certainly say it's not a mistake, to have the assertion that the maximum agricultural production we could have here would be 8 to 15 cow-calf pairs. That's it. For an entire 710 acre property, you could only actually support 8 to 15 cow-calf pairs. That's not very many in order to come up with an agricultural use. Now that letter goes on to say that you might be able to get as many as 30, but that would require you to rotate half of them off for a 6-month period and send them somewhere else to graze. In other words, they agree with us that the maximum use for grazing is 8 to 15 cow-calf pairs. That's it. That can be supported as a grazing operation on 710 acres. This is not ag land, and it can't support that. So I'll just say that now and answer any other questions you have. Otherwise, reserve time.
Okay, thank you. I don't have any other questions.
Thank you so much.
You're welcome. Does the applicant have additional persons to testify? I'm assuming I'll hear from Soils. No? No? Okay.
I think we're going to reserve potentially for rebuttal.
Okay, great. All right, thank you. Okay, so I guess at this time we will hear from persons in support of the application, whether online or in the room. We'll start with online. If anyone online is in support of the application and wishes to testify, please raise your hand so you can be elevated. Okay. Anyone in the room that wishes to testify in support of the application? Okay. I saw movement. No? All right. Okay. Now I will ask for testimony in opposition. We'll start with online, and we did go through quite a list of people. I guess I will just go ahead and remind everyone, you will all get a turn, and I really want you to use your time, but if you can refrain from saying what you've already heard others say, that would be appreciated for everyone here tonight. So thank you. Go ahead and start down our list.
Thanks, Hearings Officer Marshall, and we'll start down the list. And so first up, I have Ryder Redfield. Ryder, we will elevate you to panelist so that you can unmute and provide your testimony.
Hi, good evening. Can you hear me?
Yes.
Okay. Well, I have, I guess I'll start with a brief introduction, but I am a sixth-generation Oregonian, born and raised in Sisters, and I have lived on Lower Bridge Way since 2015. I manage 1,300 acres, all within a couple miles of the proposed development, and rather than list, my myriad of reasons opposed to this, I would like to actually express some legitimate safety concerns based on observation. And because I know we're going to hear a lot in regards to water and development and wildlife. And from the last 7 years living right on Lower Bridge Way, I have observed, I guess my biggest concern is increased amount of traffic. And whether it be access via Coiner, Buckhorn, the Gravelly Road at Buckhorn, or from Lower Bridge Way, I legitimately have concerns about safety of more human beings coming here. I have my biased reasons. I have family. I live there. But apart from that, as a human being, for wildlife and other humans, I want to express my concerns. And one thing is, it's a very windy, if you were to access from Lower Bridge Way, it's a very windy road, a lot of blind corners, and already there's too many, there's too much traffic for how what the road can handle. And I have seen so many accidents just in my 7 years there. I've called 911 on numerous occasions. We've had people go through our fences. I've peeled my chocolate lab off a highway. My sister-in-law and my beautiful niece had to dodge a collision and totaled the car and miraculously survived. I've just seen too much firsthand. So my concern is, with increased traffic, what we'll actually witness there. And as we have, sorry, there's other people in the room talking. As time goes on and the development occurs, there's going to be contractors. There's going to be, say there eventually were 70 homes. That's 140 potential cars traveling each day. If I have these concerns and fears already based on what's existing, I don't even want to know what's going to happen. And then if we talk about from a wildlife standpoint, I could not count how many deer I've seen killed in a very essential wildlife corridor. I've peeled I've found great horned owls hit on the road, and I know that's part of life. I know that's the fact of what's going to happen with human encroachment. And one who feels deeply for nature and for humans, I understand I'm going to be extra sensitive to things like that, but I just can't even imagine what is about to occur as Central Oregon expands, as Lower Bridge expands, and it just, I just wanted to share that I do have my concerns from a safety standpoint. I could go into great depths if you want to talk soil, if you want to talk farming, if you want to talk all of that, but in regards for human beings, that is a potential area of high risk. And rather than me just give my opinion and my observation, I would encourage anybody who's interested in this development or just experiencing firsthand, if you were to drive down to Bordenbeck Park or to Teeter Avenue, and post up in the afternoon or any time of heavy traffic and just observe firsthand what it's like down there. It's chaos because people are speeding, you're coming through windy corners, and it's actually scary. I've locked my brakes up so many times. It's already a risky scenario. So I'm actually like almost terrified of thinking what would happen with more people. And I know development's inevitable. I understand. The applicants, they seem like kind humans, and I'm not trying to go into, I'm not going to get into the whole anti-development concept. I'm just expressing my concern of human safety. And one last thing I would like to say, as I just landed, so I'm surrounded by a lot of people. I just got off an airplane, and I realized how important this was to me. So I'm distracted and somewhat nervous. So I just want to express that. But I flew over LA today, and as I was looking out the window, I got goosebumps, and my heart actually hurt realizing that that was once somebody's Lower Bridge Way, and change and development I know it's inevitable, and but I mean this is human nature. It's so predictable that we're going to continue to expand, and I just really wish we could do it in a more strategic, safe approach. And so the concept of rezoning places that were already deemed rural and agricultural zoning, there's a reason it was zoned that way in the first place, and I would just love if we could respect those initial zoning rules and respect the areas, the residents, and the human beings that live within. So that's my babbling, my nervous speaking, but I thank everybody, and I'm happy to talk in another format. So thank you very much.
Thank you very much, Ryder. Okay.
Next, we'll move on to Becky Powell.
Okay.
Okay, can you hear me?
Yes.
I submitted testimony on behalf of the League of Women Voters, and we have not had time to review a couple of the proposals that have come in, especially the ones on water from GSI Solutions. Also, I did not understand that we had access to their partitioning plans, and I would love to see those before we close comment on this issue. The water, this staff's done a wonderful job, and I know you're just overwhelmed with stuff, and we really appreciate the professionalism of the county planning department. But the comment on water and the fact that taking this out of agriculture would in fact save water and put it back in the river is mistaken and misleading. And in fact, this would probably lead to groundwater withdrawals through exempt wells. And those wells can remove 15,000 gallons a day for 1 to 3 homes. So the water requirement of a 700-acre development would be considerable. Also, the comments by the developer about affordable homes. I don't see that any homes with 10-acre parcels in that area would be in fact affordable. There's a house in downtown Terrebonne today on sale for $1.5 million, and it's not in any way special. So I would like to ask to be able to comment further after I'm able to look at what LCDC has come up with and what they've addressed in terms of groundwater. And thank you.
Thank you, Ms. Powell. I'm noting your request, and we'll address leaving the record open at the end of the hearing tonight. Thank you again. Okay, next.
Next, we have Scott Hayes.
Okay.
Scott Hayes, 10135 Northwest Coiner Avenue, Redmond, Oregon. Thank you, Hearings Officer Marshall. Our property, along with Gary and Lisa Bendix and Cindy Weatherthal and Eden Central Properties, share a common CC&R. We were asked to modify our existing CC&Rs, and we were told originally that the intent of the 700 acres was to establish 10 to 12 million dollar plus homes on the existing designated home sites. An additional request was made to establish a landing strip and heliport. Several months after we signed the CC&Rs, we were reapproached again and advised it was now their intent to change from a agricultural to an RR10 and build 70 homes. I bring 4 concerns to the hearing tonight. Number one, and I don't want to repeat a lot, but I will be brief, wildlife. We have a considerable amount of wildlife in this area. Turkey, elk, coyotes, jackrabbits, deer, and eagles all live in this general area. Much of the wildlife lives on that 700 acres, and it travels through our properties to get to the grass fields in the lake adjacent to us. Our concerns is that 70 homes will have a substantial impact on the wildlife in this area. We have already experienced the loss of some wildlife habitat over the past several years, especially deer. Emergency access. Access to this area is a 2-lane paved road. It's approximately 3.5 to 4 miles to Highway 126. Basically, there is one way in and one way out. There is one unimproved dirt road between 91st and 74th, which most of it is a single lane in some area and probably not navigable by cars. Our concern is that emergency access and evacuation during major incidents could occur. According to fire officials, the Grandview fire was only 16 miles from our area in 2021. Fire remains a major concern to all residents in this particular area, especially since we are surrounded by a considerable amount of juniper and bitterbrush, which we all know burns well. We've touched on water. There's been a substantial impact on wells in our area. Already multiple residents and pivot fields in our area had to re-drill their wells. 70 additional residents have the potential to create a drop in our water levels and will require more residents and farms to re-drill their wells. Agricultural area, I know they have touched on that a lot, but if you look at an aerial view, you will see that this area is very heavy in agricultural, from farming, cattle, horses, and llamas. It is not a residential typical area that you would normally speak of. We only look to be reasonable. However, we do not believe that 70 homes on this particular this particular piece of property would be considered reasonable. So this concludes my testimony. I appreciate the opportunity to address the hearing.
Thank you, Mr. Hayes. I don't have any questions at this time. I appreciate it. Okay. Were we able to connect with Dell Johnson?
Yeah, we'll try again with Dell, see if we can get him. We'll elevate Dell. Dell, we're elevating you to panelist. If you're able to unmute.
Can you hear me?
Ah, yay.
Yes, we can.
Oh, jeez.
Dell, before you start, sorry about that.
That's wonderful.
Before you start, could you just state your name, first and last name, and mailing address, and if you're in support, opposition, or neutral?
Hi, sir. Certainly will. I'm so delighted to have overcome my technical challenges. I am Richard Dell Johnson, and I'm speaking for Richard and Lori Johnson. We are landowners of an 80-acre farm that is located at 3848 Northwest 91st Street. It's the only road serving the applicant's land. Here is a quote from the application that these people are making to remove more land from EFU. Homes are not negatively impacted by farming practices. No, I said that wrong. Homes are not negatively impacting farming practices. Well, one of the purposes of exclusive farm use is to preserve and maintain agricultural lands and to serve as a sanctuary for farm uses. Water tables in our farm have declined 20 feet since we started farming here 30 years ago. Further pressure on this valuable resource will certainly increase the cost of farming. Increased traffic on our road will, with the proposed changes, will lead to more difficult use of the road for farm vehicles. They claim that this land is not usable for agriculture. Today, it may be less than prime farmland, but changes in agricultural practices are happening fast. This area could easily be used as valuable farm ground. Technology now has floating dairy farms, which are being used in overpopulated areas to provide food and milk. You can imagine the possibilities for this land, especially with the innovation in irrigation. EFU land is specifically designed to protect this ground as potential farm ground and as a wildlife sanctuary. Adding this number of homes will certainly increase the cost of farming in this valley and will be a powerful disruption to the wildlife sanctuary that the land currently provides. The application, until I heard testimony from the advocates today, did not address the powerful impact on wildlife habitat. This area is a deer and wildlife migration area. It's an active deer and wildlife corridor. This is from the overview of Deschutes County Agricultural Lands Program, Wildlife Resources. And I quote, part of the benefit of Deschutes County EFU zoning is to protect wildlife areas. This is one of the county's goals, to conserve important wildlife areas and permit development compatible with the protection of wildlife resources. The following is from Laura Turner, the Forest Wildlife Program Manager for Deschutes National Forest. Development can have direct impacts to mule deer and wildlife habitat. Building roads, fences, trails, and supporting infrastructure disrupts mule deer habitat and travel corridors. Compounding the loss of habitat is associated with the increase in the range and results in humans being present during critical times. Increased energy expenditures to avoid people and using more marginal habitats can affect deer body condition, survival, and ultimately their population. As human populations continue to grow and expand and the ability to access more land increases, disturbances to mule deer habitat increases. Advocating this zoning change is a powerful legal team that has presented an excellent argument for taking even more EFU ground for development, but they have left unexposed the negative aspects of this zoning change. The investors bought this EFU property on the speculation that they could change the EFU zoning and develop this area at a greater profit because there are lots of inventory for rural residential developments closer to Redmond and Sisters. You have all the information you need, which clearly shows a negative impact on farming and wildlife habitat. I ask that you deny this application to remove even more EFU zone property. That's the end of my statement. Thank you.
Thank you very much, Mr. Johnson. Okay, next would be Nunzi Gould.
Next, we'll elevate Nunzi Gold to panelist.
Hello, can you hear me?
Yes.
Perfect. I have a question, hearings officer. Do you live here in Central Oregon?
I do.
And do you live in the city or outside the city?
I live in the city.
You live in the city. A couple of things that I find really super interesting is many people who are making decisions for our community are not familiar with the rural area, are not experienced in farming, know little about grazing or animal husbandry or hemp farming or marijuana farming or any of those things that are currently happening on farmland. And so when they look at photographs, for instance, of rocks and small juniper trees, they come to some conclusion that the land is rocky and unsuitable. And so I would just like to chime in that there are lots of things you can do, for instance, with cattle on rocky ground. You can have a feedlot, as a for instance. There are lots of other types of farming practices that you can do on rocky farm ground. And some of those other examples that I've given you are witness to those. The other question I have for you, Madam Hearings Officer, is, are you familiar with the Deschutes groundwater mitigation rules?
You know, I entertained your first question or two, but I don't feel like I'm a witness or I should be, asked questions. So I'm going to be reviewing the record, and if that plan is in the record, then I will be reviewing it. I have the temptation of going into how long I've lived in Central Oregon and relatives that have been engaged and still are engaged in farming, but I'm not going to go there because, again, my background, other than as an attorney that's reviewing the record and the law.
I'm trying to just understand kind of the basis of awareness and understanding of things that are being talked about. So the Deschutes groundwater mitigation was based on USGS science that showed that our surface water, snowpack, springs, and river waters are connected to our groundwater aquifer. And because of that, groundwater extraction under a water right would need surface water mitigation. Now, a well that has a groundwater right is required to mitigate for its consumptive use under the Deschutes Groundwater Mitigation Program and put in stream the consumptive use of what it would suck out of the ground. Now, an exempt well, which is a well similar to the one for the house that is currently on the property, is exempt from groundwater mitigation rules. And what that means is it has a straw in the ground into the aquifer, the same aquifer that is connected to our rivers and springs, and it does not need to mitigate. And for that reason, any new groundwater straws put into the ground under exempt wells are having an adverse negative impact on our surface waters because they are not mitigating. And for that reason, it is paramount that if this ridiculous subdivision is granted, that at minimum, a community well with a water right that has to mitigate under the Deschutes groundwater mitigation rules be a very condition of approval so that we do not have adverse impacts on our river and springs that are nearby. And nearby, let me share with you, we have the Deschutes State Scenic Waterway, that's the Deschutes River. We have the federally designated Wild and Scenic Deschutes River, and we also have very precious springs that recharge our river. These are very important because PG&E, as you may know, is reintroducing salmon or steelhead into our ecosystems. And the ecosystem is the Deschutes River, right near this property. The ecosystem is Wychus Creek, where we're spending a lot of money remediating the stream so we have places for young fry and places for spawning. So what's critical right now is that we don't withdraw any water under any exempt well status. So that is my kind of very quick overview on why just allowing exempt wells to further go down the pike has an adverse impact. And I think in the testimony from ODF&W, they speak to habitat, they speak to cold water, and they also speak to the importance of springs. So the other thing I would say is we do not have infrastructure at this 700 acres. Yes, I get that their one house might be off-grid. I highly doubt that 70 properties are going to be off-grid. And certainly the proponents of this development, those who gave their address and sisters of a PO address, a post box address, they're not living in the post box. So it would be wonderful to know where those individuals actually reside so we can better understand their focus and their interest. Affordable housing is not what's going to be built on a 10-acre rural property dozens of miles from any job, okay? There's no transit at these properties. I think on a snowstorm, at best, it would be questionable as to how long it would take for the county's snowplows to actually clear the roads to get you to these places. So this notion that this development is leading towards affordable housing, I think is a little bit far-stretched. And certainly it's not where you would even want affordable housing if that were what you were trying to build. But I think it was clear that the applicants were trying to justify that the investments and the remuneration from this could possibly help on their donations to other causes. So the infrastructure for jobs might be in the unincorporated community of Terrebonne. The infrastructure for jobs that actually have a septic system would be in the city of Redmond, the city of Madras, or the city of Bend, or the city of Sisters. And currently there isn't any transit system from this development that would even, there's no bus system to this rural community. So the rezone capabilities, I think, fail the litmus test because agricultural practices have occurred on this land in the past. The property, certainly in one circumstance, has received farm tax deferral, perhaps not under this owner, but in previous circumstances. The other thing I would like to chime in that you've heard eloquently by Del Johnson and Ryder, I can't remember his last name, is the wildlife habitat in this area. And I know that the applicants, Ken Katzeroff, spoke about Ms. Wente, who's their consultant. And I might just add that Ms. Wente was hired by the county to do a wildlife habitat update for the county. And it is kind of slapping our community in the face when Ms. Wente continues to be hired by this law firm to be developing habitat, wildlife habitat areas. In one case, it's a water ski lake. In another case, it's a private airstrip. And now we have fragmentation of rural lands into 70 rural residential lots. And in particular, Ms. Hearing's officer, there is golden eagle habitat near this property, and that is an important thing to be protecting. The most current wildlife habitat recommendations from the U.S. Fish and Wildlife Service and from ODF&W suggest a 2-mile radius from golden eagle territory, and it is to protect from the deleterious effects of human encroachment. Humans fragmenting land and humans' movement, sound, development, cutting of the native habitat, doing things like putting in a half acre of yard, which is common. Those are things that remove wildlife, the indigenous species, native vegetation that we have. And so from those perspectives, I am opposed to this development. It is not in the right place, and it is certainly not in the right time with the extreme drought that we've been having. I would like an opportunity to review the new materials that the applicant has submitted. This seems to be a pattern from this legal counsel that represents developers. They're always throwing in a whole bunch of new materials like the day before the hearing, or even within the 7-day or the 7-day rebuttal timeline. And frankly, I'm not sure that agencies are being given the opportunity to give comment on these things. And so, for instance, on the 19th, which is today, you received testimony from 3 state agencies, and yet today it was announced that the applicants have rebutted on that already. And so I think it's really important to keep a timeline to understand what was in the record when comments were made, and if there are new informations into the record, how the county shares that with those who have commented before, so we would know that there's actually new stuff in the record. And this is a pattern I've seen multiple times with this particular law firm and with Mr. Katzeroff and with Mrs. Wente. I'm sorry, I can't remember the firm that she might be represented under, but I do think that there is a conflict of interest since she was hired by the county. If she now is going to be representing developers within an area that was mapped as wildlife habitat for mule deer. And I would again say the area is within the 2-mile territory of golden eagle habitat. And for those reasons, I think I'll just end my testimony. And I don't mean to be flippant in my commentary, but I do recognize for people who turn on their tap in a city, they're very unaware of what is happening in our rural community with what the mitigation rules are, what is exempt and what isn't, and frankly, what is happening in our ecosystem this particular year. And I might just finally add that the Three Sisters Irrigation District has water rights that you're seeing within the green pictured images that the applicant submitted. So if you look at the photographs that they submitted in the PowerPoint and you see the pivot areas that are the little green areas off the side of those precipice rocked areas, that land is in the Three Sisters Irrigation District. So the Three Sisters Irrigation extends down to Lower Bridge, and those are examples. There is capability to find water rights in our community, and this developer is choosing to spend their money not on perfecting their farm, but trying to annihilate their farm. Instead, they're spending money with the lawyers and with the consultants and with all the development, marketing, shindigs, whatever it's going to be, to try to partition out our EFU zone lands. And for that, I stand that it's not in the best interest of our community and it's not compatible with our comprehensive plan. Thank you.
Thank you, Ms. Gould. Okay, I'm not sure if the applicant's transportation engineer or, well, we've heard from Mark, so perhaps next would be Pam Mayo Phillips.
Yep, we'll elevate Pam Mayo Phillips.
My name is Pam Mayo Phillips, and I have been a realtor for 33 years and deal primarily in ag properties. And ag properties and residential do not go together because of farming practices on baling at night, farming during the day and hearing the noise. But I just wanted to emphasize a little bit on your well water rights. The well water rights have significantly dropped in our area. And yes, I know that they're not going to use this for ag, but per financing, it is about 5 to 7 gallons per household, and you add that 5 to 7 gallons per household, that's 1,000 gallons, real close to 1,000 gallons that will be taken out of our aquifers, will significantly impact our area. Grazing, I deal a lot with grazing properties, and if this property was fenced, it would definitely accommodate approximately 30 cows, and there are many areas in Deschutes County, Crook County, and Jefferson County that they raise the cattle on this type of property. And and then I want to talk a little bit about the traffic. We live on Spruce, which is not county maintained. We put our own money in and put gravel on the property. And Coinier is a chip seal. It is not, will not accommodate all this traffic. Then there is also an applicant that will be for RR10. It's a possibility in a couple years, and I have talked to Deschutes County quite often, that they're going to allow ADUs. So if every home is allowed an ADU, that is also going to be significantly impacting the traffic and the water. And I appreciate having a chance to talk. Thank you.
Thank you. Thank you very much. Paul Lipscomb?
Paul, we've elevated you to panelist. You'll want to make sure to unmute.
Thank you. While this hearing was going on, I heard that the 3 state agencies had weighed in on this application, and I wanted to see what they had done. And I was flatly amazed. I have not ever seen this before. We have a joint letter entered into the record by the Department of Land Use Conservation and Development, by the Oregon Department of Agriculture, and by Oregon Department of Fish and Wildlife. All 3 oppose this, and their conclusion is this: based on our review of the application materials and for the reasons expressed above, we believe that the subject property qualifies as resource land. It is our recommendation that the subject property retain an exclusive farm use designation and not be converted to allow residential development. I'd like an opportunity to comment on that in writing, and I'd ask you to leave the record open for 7 days.
Okay, thank you. Thank you very much, Judge Lipscomb. Okay. Leave record open. Next was on my list was the applicant, then the soils engineer, and then Robin Vora.
Robin, you're now elevated to panelist. Robin, you may need to unmute your microphone there on the bottom left-hand corner of your screen.
I'm Robin Vora. Did you want me to speak next?
Yes.
I'm sorry, I can't, I'm not hearing.
Robin, can you hear? Yeah, you're up next to give your testimony in opposition for the application.
Turn off your.
Robin, are you able to hear?
I'm not sure what's wrong.
Robin, we can hear you, but maybe your.
What am I doing wrong?
Your sound might not. Robin, you may need to make sure your computer volume is turned up so that you can hear us.
Can you hear me?
We can hear you, Robin. Are you able to hear us?
I can't hear her either. So. if she said something wrong on the system. Nothing I can do, right?
Rob, and I don't know if you can hear me, but you'll want to just check your audio settings, making sure your sound is coming through your computer.
There's no comment.
Okay. Robin, we'll go ahead and we'll keep moving through, if that's right with hearings officer.
Yes, I believe we should, yes.
Okay. We'll try you again. But again, I believe Robin had submitted comments via email as well, so we'll have those uploaded to the record.
Okay.
And Robin, if you had any other comments, you can email them into me.
I'm not coming in the video either.
Okay. We'll go ahead. We'll move on to Tim Phillips. Tim, you're now elevated to panelist. If you'd go ahead and unmute, and you can provide testimony.
Okay, can you hear me now?
We can hear you.
Yes.
Yes. So my comments are, I listened to the presentation by the applicants and their strident appeal to great virtues for what they're trying to accomplish. But we all know that development is about the money. And so I need to cut to the chase. There is no question about why this development is happening. And the impact on the neighborhood is the issue that I'm concerned about and concerned about in all Central Oregon neighborhoods, is that we are scattering out and developing land that is marginally useful for agriculture. There's no question about that. That's not, wouldn't take a scientist to accomplish that, or a law firm from Seattle. If you go to Montana, which was my native state, you can see what unmitigated development looks like. And you can scatter homes all over every hillside and make it look like, there's civilization everywhere, but it just destroys the nature of the land. And that's kind of part of what we're looking at here. So I think the nature of the neighborhood, the traffic impact, and I do feel definitely very seriously about the water impact. And I know they're going to have testimony to their hydrologists, et cetera, that will talk about what the actual impact is. And I'm not an expert on it, but we know that we're in a very drought situation, and we are in an area that is marginally acceptable for agriculture. I get that. So why are we building out and scattering homes across the landscape when we need to put them closer together and utilize the infrastructure that we have? And I guess that's really my comment on this whole development, that is definitely impacting an area that's marginally agricultural, but is very important for agriculture, the aquifer, and the wildlife, and is not really benefiting anyone except the applicants as far as the dollar amount that is being asked for. That's my statement.
Thank you. Thank you, Mr. Phillips. And then Kelsey, I don't know if I got her last name.
Yeah, looks like Kelsey Nonella will elevate you to panelist. She may have dropped off. Yeah, I don't see Kelsey either. Okay, Kelsey Nonella, if you're listening in, if you'd please raise your hand. That way we know you're still in the meeting. I'm not seeing any hands from Kelsey Nonella. Hearings Officer Marshall, I did want to note we have Robin Vora, who has raised their hand, as well as Nunzi Gold.
Okay.
Would you like us to elevate them?
Yes, and Nunzi Gold, she provided testimony. Is she asking to testify again before?
It looks like she just lowered her hand.
Okay, okay.
But it looks like Robin's got their hand
Robin,
again.
sure.
We tried to- Okay.
Okay.
We'll bring in Robin to
Yes,
testify again.
great, okay.
Can you hear me now?
Yes.
Okay, I'm sorry. I could see you before, but I couldn't hear anything you were saying, and you couldn't hear me.
Right.
I'll try there I am.
There we are.
Okay, this time it's working. Okay, good. Thank you.
Great.
I did submit an email, and so I won't repeat that. But basically, summary of my concerns are, loss of wildlife habitat, the fragmentation this will cause, the loss of open space, dwindling water supplies, stress to existing ranches and farms, the traffic issues that several have mentioned, and the housing is really not the type that we need. Obviously, I doubt if any of it would be very affordable. The agriculture question, obviously you're not going to grow plants on a rock cliff, but there's flat ground in there from what I could see in the pictures. A lot of it would be dependent if the rock is bedrock or if it's loose and can be removed. You see many piles of rocks, around many pastures and farms. A lot of this kind of land is grazed throughout eastern Oregon. Cows figured out they don't fall off the rock edges. And mitigating wildlife, it was nice to hear that there'd be some wildlife mitigations, but obviously the best would be not to impact the wildlife habitat at all. We have dwindling populations of mule deer, especially a real concern. And all these kind of subdivisions, there's a real cumulative impact of all this that keeps affecting these populations. And they're going to keep going down if we keep approving subdivisions like this. Certainly, removing juniper is nice, but the landowner could do that anyway without needing to have, one house per every 10 acres to do it. The solar is nice, but obviously the amount of energy used would be less if there were no houses at all. But it's nice to see that they're offering to do that. Nice to see they're offering donations. But I think for the community as a whole, we'd be much better off, not approving this proposal.
Okay. Thank you, Mr. Vora. Okay. Do we have any other online people that wanted to testify?
I see there have been a number of folks that have joined in halfway through.
Okay.
And so if it's all right with you, we could make a last call for any.
Sure. After we hear live in here, or I guess it's just your guess is as good as mine on procedure here.
I've got two folks that have raised their hand.
Okay.
That are on Zoom.
Okay.
So we'll elevate them.
Yeah, let's do it that way. Yes.
We'll start with Diane.
Okay.
Diane, we're elevating you to a panelist. Once you're able to unmute, if you could please state your first and last name, mailing address, and provide your testimony.
My first and last name is Diane Lozito. My mailing address is P.O. Box 85, Terrebonne, Oregon 97760. What else did you need?
Well, if you're testifying, are you testifying in support, opposition, or neutral?
No, opposition, yeah.
Okay.
So I'm a farm and ranch realtor here for 30 years, and I had that specific properties listing at one time, so I know it well. So I submitted a letter of opposition in detail. So rather than waste everyone's time, you can see that letter later. What it consists of is at the very top of the hill is rocky, but nothing else is. So if you were to enter from Coiner and go uphill to the very top tax lot, that's where the previous owner that I represented built their off-the-grid home. That home has, of course, off the grid, no power. So when I had the listing, it was very expensive to connect to power at all. So a lot of people were not interested. Then down the hill from it, the land does look like it's pretty good soil, and it's surrounded by excellent hay farms. So I would like to see a detailed study, a soil analysis study of that entire 700 plus acres, so that the applicant can prove that it's not farmable. It seems suitable for grazing. And what it was sold as, instead of farming, the previous owner sold it with LOP hunting tags. So that was the business of the day that worked for them then. I think it's very selfish for one owner to profit while chopping up EFU land. And EFU land that's so landlocked, one way in, one way out, a long distance from a major access road, makes no sense at all. It's just another example of poor planning in Deschutes County out of desperation for creating more tax revenue. I think it's a terrible idea. And then the one home that is there, note that their well log, which I've attached to my letter, is 490 feet deep. So if they're going to start drilling wells, I already have 11 clients in the area whose wells have gone dry. Why would you add 74 wells, to me, of wasteful use when people around them are trying to farm and make a living? Thank you very much.
Thank you, Ms. Lozito. Okay, and
before we let Diane go, Diane, could you just confirm the spelling of your last name?
Sure, it's Lozito.
Thank you.
Thanks.
Looks like we have one more hand raised on Zoom.
Okay.
Adele Somner will elevate to a panelist. Adele, if you could please, once you unmute, state your first and last name. Please spell your last name, provide your mailing address, and your testimony.
My name is Adele Summer, 67134 Gist Road, Bend, Oregon. I meant to say earlier, or in my letter, that also the light pollution, part of the joy of this area is that it's not so polluted with light that people that are actually out here can actually still see the stars. Having that many homes would have quite a large effect on it. Also, the big mine is no longer being used for homes. That's now a wildlife reserve, to my knowledge. And that's all.
Okay.
Already sent a letter in regarding the traffic and the imminent danger that we have, especially on the curve of the road there by the Gordon Beck Nature Reserve there. People are always walking across the road there, and it's just so dangerous. We just wish people the best. Thank you.
Thank you. Thank you very much. Okay, anyone else online?
There is one more person, Tim Phillips, who
Okay.
has raised his hand. We will promote him to panelist.
Did he? Okay.
Tim, if you could please state your first and last name, mailing address, and provide your testimony, please.
I think you did, yeah. Yeah.
Oh,
Okay.
yeah, I think Tim did already speak.
Yeah.
Okay, and I don't see any more hands raised on Zoom for those in opposition.
Okay. Great. All right. So now we get to go to live testimony. And I see 2, 4, 6 folks in the room, and you have your hand up. Do you have a question? No? Did you have a question, Ms. Macbeth? Okay. All right. So we will go ahead and turn it over to those who wish to give testimony. If you would, as Holly said earlier this evening, come up and write your name and address on the sign-in sheet there. Take a moment to do that and state your name into the record. That would be helpful. So whoever wants to take the lead, now's your chance.
Thank you so much for holding this hearing. I'm William Buchanan. My address is 10142 Northwest Coiner, Redmond, Oregon, 97756. And I am in opposition to this proposal. We live to the, it would be the southeast corner of this property, this adjacent property. We have a ranch over there. We own Keystone Natural Beef. We sell locally sourced grass-fed beef. We deliver it to people locally within Central Oregon. Free delivery. I'm a 5th-generation rancher. If there's one area of expertise that I have in my life, it's probably with a cow and grazing on rangeland. And I will tell you with absolute certainty that the legal counsel representative is 100% wrong on not being able to graze that. I have done far more with far less. And it's, sorry if I sound a little passionate about this, but there's numerous ways that you would be able to graze that piece of property. And I understand that it's not tillable, but that's fine. We have over 27% of our land mass in the United States is rangeland. Most agricultural lands are rangeland. Over 500 million acres is rangeland. That's pretty substantial. This is over a square mile that could be grazed. I've grazed on rockier slopes, and to answer your question earlier, I prefer to graze on those slopes. We have a fall calving program where our cows are not raising a calf over the summer. That's kind of the ideal terrain that I would put those cows in, so they don't get too fat. They can break off their long hooves, and they don't become so obesely fat that they're not breeding back during a breeding season. In more creative methods of how you could graze this piece of property would be to incorporate dryland grasses, whether that be a crested wheatgrass, perennial ryegrass, or Idaho fescue, which is primarily native around that area. It's highly tolerant to grazing, and it only requires 18 inches of rain or less. It actually can't take more than 18 inches of rain. So I'm really going to challenge these comments earlier about the stocking capacity that the legal counsel brought up. That's not what it says in the report, that you can only graze 15 cows on that. I read the report before I came in here, and it's actually double that, and that's annually. That's not seasonally. So it says in that report that you should be able to, on an average year, have one cow-calf pair per 10 acres. That's 70 head. And we rotationally graze all the time. I mean, we'll set up temporary fencing, we'll rotate. We can actually increase vegetation flora by doing that. We can actually increase our soil quality by doing that. We do it at the neighboring property right now. We're one of the few farms that's in the area that's not using a fertilizer application because we feed all winter. I think that these are very important points, and the law states whether or not this can be used for agricultural purposes, and it absolutely can. There's absolutely no question. And if there is an appeal, I mean, I will submit every bit of evidence that I can, based on what I know and what I've researched. It's very viable to utilize it for that. I'll bring up another point. When I was a college student, this was 2004, 2005, I believe. I was a college freshman. And one of my professors, this was in an ag class, he asks the class, what is the greatest challenge to modern agriculture right now? And there's numerous guesses throughout the room. And without hesitation, he says, new development. The price of our land and what it costs to operate is putting us out of business. And we make up 1% of the population. We have 1% that grows your food. Everybody in this room is involved in agriculture. I mean, including myself. We buy food at the grocery store. You're involved in agriculture. And there's an increasing demand for locally sourced. If we're pushed out of business, and I'm only in the somewhere around 25% age range of new farmers that are getting into the industry. The average age for a farmer now is 57 years old. There's fewer and fewer people that are getting into it, not because they don't want to. It's less and less affordable. And most of that is related to the land prices and what it costs to operate, what it costs to start up. And I suppose I'd have no problem growing your food 2 hours away, but that's not what I want to do. I have a relationship with my customers right now, and I would hate to be pushed out because of increasing property taxes and this development that keeps on continuing to push us out of the county. Over the last 2 decades, it's been just gone rampant as far as growth. And it's a tremendous challenge for us. But the law states that it can be used, if it can be used for agricultural purposes, it needs to remain an EFU. This is why the law was written. I have nothing further.
Okay. Thank you, Mr. Buchanan.
William, can you, please sign in. Thank you.
She can fill it out for me.
Right. Just want me to state my name and
Yeah.
you probably don't need the address.
For the record, it is written down, but yeah, just because we're recording this as well.
Okay.
I appreciate it.
Elizabeth Buchanan, and the address is 10142 Northwest Coiner Avenue, Redmond, Oregon, 97756.
Thank you.
So we share similar zoning to the subject property. As my husband was saying, we have a ranch that is essentially, would be connected other than the road like dead ends there, and there's just a small piece of pavement you could practically jump across, and there is that subject property. So we know the property really well. I walk the dogs out there. There's BLM that is actually right next to it. you know, we're very familiar with it. We would have loved to purchase it and to expand on, so we have, you know, looked at the property and know quite a bit about it. But what I wanted to say is that I did look up Deschutes, on Deschutes.org. It says the entire purpose of the EFU zoning, just in case anyone doesn't know, the basics, it specifically says, the purpose of the exclusive farm use zone is to preserve and maintain agricultural lands and to serve as a sanctuary for farm use. Uses, it's plural actually. It doesn't say for cattle grazing or, you know, it's uses. Like, we're young, and young people farming nowadays, we can come up with all kinds of, you know, I'm an entrepreneur, I'm successful, I could guarantee you 100% that land has farm use. You just have to use your brain and think outside the box. It's not all about how much grass a cow can eat. Come on, like, that's so old school. So we own a very successful all-natural, we raise all-natural grass-fed beef. It's called Keystone Natural Beef. You've probably seen us all over in the Smart Shopper, Red Bee Press. We're in all the local magazines. We do the local home shows. We're really involved with the community. It's my husband's, it's why he wakes up in the morning, pretty much. So we, essentially, in order for us to expand, we need more land. We would have loved to have bought the land that connects to us. There's an 80-acre piece. Well, the county gave them, without us knowing, they're building on that now. So we can't expand to the one side of our property. The only other side would be this 700-acre piece if we did want to expand our operation or go out of town, which clearly, like, we're not going to go farm 2 hours out of town when it's just really not viable for us. So we are feeding the community, and we did. So we currently, the piece of property we own is 36 acres. We did $80,000 in beef sales last year, just on that piece. Most of that, a lot of that is dry land. So to say that, he was trying to say that, the OSU stated that the formula says for that 700 acres, it averages $48,000 a year in income. Well, I mean, we have our taxes, we do a Schedule C, we farm it, we farm our ground, we made $80,000. So that's on 36 acres. So I'm pretty sure that with 700, we could do a lot more. So, let's see, kind of covered most of that. We just feel as though that this location is not ideal for growth. It's on a dead-end road. It's all farm ground. I don't know if you've been out there or seen it, but it's all farmland, and everyone around us is farmers. To have homes, 10 acres, I mean, I personally don't know anyone that lives on a brand-new house on 10 acres that are farmers. I mean, the people that are those, you know, generally that brings in a different crowd, and I'm not sure if that would go well with the community that is out there. I feel like it will cause a lot of conflict. And just one of the other things that there is a shortage of right now are, is up and coming is chicken, and chickens can be raised all over on that property. So to say it's not farmable, I mean, there's a huge deal with the chicken influenza. Like, there's a pandemic right now. A local farmer could solve that by having, you know, free-range chickens out there. You don't need grass. We would love to add that on. Our clients, because we do beef boxes and we have beef memberships, and our clients would love to be able for us to add on chickens. So that would probably be our next endeavor if we could, you know, expand. So I guess we just really ask that you really look at the law and the intent of it. We don't want our ground to be fragmented, and we just ask again that you adhere to the current zoning laws that were put in place for literally this exact reason. This is why they were put in place, so developers wouldn't come in and fragment the properties. And it specifically says that it's zoned for it's a sanctuary for farmers, and we're asking that you leave it a sanctuary for our animals, the animals we grow to feed our community. So that's the end of my statement.
Thank you.
Thank you.
Thank you, Ms. Buchanan. Okay.
Good evening.
Good evening.
Marshall. I'm John Jennings. I'm the Community Services Specialist for the Oregon Department of Land Conservation Development. Happy to be here tonight. It's the first public hearing I've been to in a long time. And I want to say hi to the folks that are on Zoom that I know. I was hoping to see my old friend Liz Fancher tonight, but I guess she didn't make it. We wrote a letter. By we, I mean the multi-agencies, Oregon Department of Agriculture, Oregon Department of Land Conservation Development, who I work for, and the Oregon Department of Forestry, Oregon Department of Fish and Wildlife. I was in a Senate Bill 762 meeting on wildfire earlier today, so I apologize. I'm not going to read it. It's pretty detailed, and I think includes a lot of information which we hope will be helpful. The upshot is we're recommending that the county deny this proposal, that we retain the existing exclusive farm use zoning. We have a number of reasons for that. I'm going to defer to the Buchanans on grazing suitability. That's a big part of our piece too, but that's a tough act to follow, so I'm not going to try. But I have a couple things I would like to say, and in general, as we kind of look at these sorts of issues, most rural residential neighborhoods have been designated through what we call an exceptions process, and this isn't news to the planners in the room. But that is really to recognize an existing situation, an existing settlement pattern that really irrevocably commits an area from being available for commercial farming or forestry. And the zoning strategy that follows, which is guided by our administrative rule in Division 4, OAR 660-040018, requires that it be compatible with existing uses. And really it's about maintaining what's there, right? Maintaining the existing character of the area. It's already developed with homes. There's already existing pattern of infrastructure and services. And so we want to kind of keep it like it is. The applicant's not requesting an exception, and that's because it's not an existing neighborhood. It's barren land. There's nothing out there, which is fine, but it's different. So with an exception, with an existing development pattern, existing settlement pattern, you're looking kind of keeping things the same. And with this type of approach, what's often called the non-resource approach, we're contemplating changing it forever, as opposed to keeping it the same. We're changing it forever. So that's just kind of some context, and I kind of tend to do that a little bit. I wanted to take a second to offer some thoughts on some of the things I heard tonight from the applicant, which were new to me, and that's probably my fault. But I would point out, I guess, and I don't think, again, this isn't lost on anybody, but in the spirit of raise it or waive it, I've just seen raise it. Needed housing is defined in our statewide planning goal 10, and that's further implemented and interpreted through your administrative rules at OER 660 Division 8. And really says needed housing is in urban growth boundaries. It's come to urban growth boundaries, a variety of housing types at variety of housing points. There is no need. There's no legal need for rural residential housing. It's an urban thing. It's something that's in urban growth boundaries. Certainly we have rural residential housing opportunities, but there's no need for it. There's no legal duty for counties to supply it. I was impressed and enjoyed hearing the sentiment about sharing with others. I like that idea. I respect that. There's other ways, I think, to share the property with others than developing it. The exclusive farm use zone offers a number of uses. Private park is one of them, or trails or other things. So again, there's other ways to do that. I found the kind of repeated mentioning of the destination resort stuff interesting. Now, some might call it peculiar. I'd call it interesting. But in addition to that, the interest in doing really good things, using solar is great, contributing. And I didn't understand the applicant to be talking about developing affordable housing. I understood them to be talking about perhaps contributing to causes that promote that. That's great. The high taxes is shocking. That's a lot of money. But I don't think they're relevant. I don't think they're relevant in this instance. They make their own choices, but I mean the claim to do good things, or which I have no doubt in their sincerity in doing that, or to remove the potential for a destination resort. Again, maybe that's good or bad. I don't know, but I don't think those align with any of the applicable criteria. I certainly don't align with any of the state criteria. Land is rocky up there, but it's not all rock. I've been up there too, and in fact, it looks just about like a lot of this country that I've covered, having grown up here in Deschutes County. I spent a lot of my time here. Grazing on steep slopes does occur, can occur. Ask the guys in Hell's Canyon or the Minnehaha River Breaks or Joseph Creek. They gather horseback those pastures that I wouldn't want to walk on. So, and I as I was coming back from the Boardman area along I-84, you look on the side of the Clinton River Gorge, and there's cattle up there. So I'll kind of pivot back now and talk about our comments. Fact of the matter is, we just disagree with most of the applicant's assertions. Again, we're not questioning their intention, but we disagree with them, and we've laid out those arguments. Been well pointed out, agriculture is a lot of different things. Raising and training equines, which I think was born out of the case here in Deschutes County 25 or 30 years ago, is pretty common. Confined animal feeding operations, raising birds. It's interesting chickens were mentioned because that's been a hot topic in Lynn County. Ask them about that. But absolutely, those are things that can happen. And even with grazing, as was mentioned, sometimes it's just really helpful to have a place to stick some critters. I was driving again down 94, and there's land up there by the Port of Morrow, and I don't know what the soil capacity is, but I know similar land nearby, near the Umatilla Chemical Depot, was Class 7 soil when dry, and this was dry. And there's probably, I would guess, let's say 40 head of bulls out there, and they'd just been dropped off. Their stock trailers were there, and they were just stuck there, set there for the time being until they were going to be gathered and kicked out with the cows. Now, 40 head of bulls may not sound like a lot of animals, but we have to realize that in an outside operation, running outside, those bulls are expected to service between 20 and 25 head of cows. So that little piece right there in that dry pasture for that time being probably represented a cow herd of 800 to 1,000. So that may not have been a big deal to everybody, but that's a pretty substantial operation. I'm sure it was a big deal to them. You know what? It's been a long night. I think I'm just going to kind of do everybody a favor and, you know, and stop for now, except to say, you know, we have offered detailed comments. I think in most every instance, we're at a disagreement with the applicant's assertion. Again, we appreciate their time, we appreciate their energy. We're just not able to get together, I think, on this issue in this context. You know, looking through this, it's the climatic conditions. It's cold and dry, like millions of other acres in the West. You know, that's kind of why they're called the arid West. Irrigation water is absolutely critical for irrigated agriculture. There's entire economies in this state that rely on dryland farming and grazing dryland areas. So I promised to stop, and I just immediately broke that promise. I'll apologize, but I will stop now. You know, we've raised a few other issues. We've raised goal 4. Here I'm going again. We raised the goal 4 issue. We're not asserting this is forest land, but we think that maybe there could be some more complete description of why it's not. But the bottom line is simply we just don't agree with the proposal, and we would recommend that this property retain its EFU status. Thank you very much. Thank you for your patience.
Oh, sure. Thank you very much. Okay. Carol, Macbeth?
Good evening, Hearing Officer Marshall. Thank you for the opportunity to testify on behalf of Central Oregon Land Watch. My name is Carol Macbeth, and I'm a staff attorney for Central Oregon Land Watch. Our address here in Bend is 2843 Northwest Lolo Drive, 97703. We have submitted quite technical arguments, legal arguments, for your review in our written comments. And I would like to take this opportunity to rebut some of what the applicant and the applicant itself and their representative was saying. And I wanted to echo Mr. Phillips' testimony when he referenced the beauty of the undeveloped rural lands and contrasted them to the sprawl that is seen in other states, or the visible development that people see from rural lands in other states, which is not possible here because of our land use laws. ORS 215243 is the legislature's agricultural land use policy. And when the legislature casts such a wide net about what is agricultural land, that technical term, agricultural land, one of the purposes that they included it for was aesthetics. It was social, aesthetic, and economic. That was the reason that they chose to protect so much land as agricultural land. And so he's called out one of the reasons that the land is agricultural land by definition. And that brings forward when the applicant keeps repeating that it's not farmable, the applicants who do not appear to be attorneys are not using the relevant legal standard. As the hearings officer knows, the relevant legal standard is agricultural land, which has a specific legal meaning in this context. It's not its everyday meaning. It doesn't mean the same thing as farmable. It means, does it meet the legal definition of agricultural land, which is a matter of law. And here, the applicant itself, Eden Central Properties, has in their own burden of proof, they provided evidence that the NRCS says that it's Class 6. As a matter of law, Class 1 through 6 land by the NRCS is agricultural land. That is so in Deschutes County's code, which mirrors and presumably implements the administrative rules and Goal 3 itself. And they specifically say agricultural land means lands classified by the U.S. Natural Resources Conservation Service as predominantly Class 1 through 6 soils. So it's not really up, there's no question about it. The applicant is referring to an inapplicable standard that they are mistaken about the law. We'd also just point out that there is no possibility of a residential destination resort on the property as a matter of law, pursuant to ORS 1974551A, which prohibits such residential destination resorts within 24 air miles of a city with a population of 100,000, which Bend now is, and this property is considerably closer than 24 air miles. I wanted to correct the applicant's misinterpretation about rockiness. According to the NRCS's handbook on land capability classification, the NRCS, which has walked the land of Deschutes County from north to south and from east to west in making its soil survey, it takes the rockiness into account. So when the NRCS classifies land as Class 6 in this case, it's predominantly Class 6, 76%. That's because if the rocks can be removed, then the NRCS has classified it as Class 6 with the rocks removed. If the rocks cannot be removed, the NRCS has classified it as Class 6 without the rocks removed. So there's no such thing as like, oh yeah, well, they may have said that, but it's really rocky. That doesn't matter. The rockiness is in it. It's taken into account expressly by the NRCS, and it is a misinterpretation of the applicant to believe otherwise. I would like to echo with the Buchanan's remarks about 48,000 and say that the applicant is mistaken in saying that 48,000 of gross income is not proof the land is agricultural land. Many farmers and ranchers in the Central Oregon would be happy to obtain $48,000 in gross income. Moreover, if this property were in farm use, its tax burden would shrink significantly to just a fraction of what it now is, so that their calculations were incorrect when he said that that was a problem, because it's not. We'd also think that the applicant is trying to shift the burden of proof in some way, in that it is only the applicant who has the burden to prove here a very heavy burden of proof that there is no farm use to which this land could be put, as Elizabeth Buchanan stated earlier. She was mentioning chickens, but there could be llamas or honey or lavender or any other of the number of uses in Deschutes County which can be used without any particular land capability. So the burden is on the applicant to show that none of those uses is possible. That burden cannot be shifted to opponents. We have no burden. We are not here to prove that it is agricultural land, although it is. It is up to the applicant to prove that it is not. And agricultural land includes not only land that, like this, is agricultural land by definition because the NRCS says it's Class 6, but also land in other classes that can be used for farm uses, such as the ones I just mentioned. And the applicant has not met its burden to prove that it cannot be used for any farm use. And I would just like to close by saying, as we put in our written remarks, the NRCS Technical Soil Services Handbook, Section 629, says that Order 1 soil surveys are supplements to the official soil survey, but they do not replace or change that data. So that's the NRCS in an official document explaining what an Order 1 survey can and cannot be used for. The applicant has provided an Order 1 survey. We're sure it's just great as Order 1 surveys go, but according to the NRCS itself, the United States Department of Agriculture, in an official government publication, that is not it's something that can replace or change the official soil survey, which is what the applicant is trying to make it do. It just doesn't fulfill that role. It has another role, which is to allow the placement of something that needs special soils, like a nuclear power plant. So the applicant is mistaken also in saying that that this Order 1 survey fulfills the role they ask it to fulfill. It does not, and it is expressly not for that purpose and cannot be used for that purpose. And we've provided that Technical Soil Services Handbook 629 for your information, as well as we've submitted the entire upper Deschutes River area soil survey for your information. And I'll close in saying that in the upper Deschutes River area soil survey, there are two levels of detail. One is general and one is detailed. This land is in the detailed soil survey, and the minimum size for purposes of management is 5 acres with an average of 40 acres, while the property is 710 acres. So this is overwhelmingly within the range of accuracy of the upper Deschutes River area official soil survey. That is, if the minimum is 5 acres and the average is 40 acres, and this is 710 acres, clearly the level of accuracy chosen by the NRCS, which is quite typical, is sufficient for the purposes of identifying agricultural land. If you have any questions, I would be happy to answer them.
Okay, thank you very much. I appreciate your testimony.
Okay.
No questions at this time?
Thanks.
Okay, thank you so much. Yes.
last but not least, I guess, huh? My name is Jeff Roberg, 8187 Northwest 93rd Street in Terrebonne. And we live adjacent to this property. Maybe we're distant neighbors, but close enough to, I think, be impacted by these people. Maybe this is a little bit of selfish reason, but we looked 5 years for the perfect property in Central Oregon. I think we found it, and now we are consider about our view being blocked. We see probably all 7 mountains, including Mount Bachelor, and we're concerned about a house sitting between us and Mount Bachelor. I'm sure that's small compared to some other people's problems, but it's significant to us. We're also concerned about the impact on the eagles. I know that's been kind of already talked about, but we live on a cliff, and we can look out our living room window and see the eagles flying just right by our house. And we think that this is an eagle flyway, which is, again, going to be impacted by housing over in this other adjacent property. So we're here to support the eagles. And matter of fact, today we looked out the window and we saw an eagle take off and pull a fish out of the mouth of an osprey. That was really something to see. So we're here for the quality of life in Central Oregon, and would like to keep it that way.
Thank you so much. And what was your last name?
Roberg, R-O-B-E-R-G.
R-O-B-E-R-G. Okay. All right. Thank you. Okay, is there anyone else? Last call for testimony, either Zoom or in person. Okay.
Hearings Officer Marshall, I'll note that we didn't have anyone who wanted to speak neutral to the application.
Correct.
So I don't have anyone on my list, and I am not seeing any hands raised on Zoom.
Okay. All right. Well, I'm going to suggest that we take a 10-minute break. I know the hour is getting late, and regroup here at 5 minutes to 9. And at that point, we'll have the applicant's rebuttal, and I will be addressing the requests to leave the record open at that time. So please come back here in 10 minutes. Thank you. Okay, thank you, everybody. We are back on the record. It's, I was going to say 9:55. It kind of feels like that. It's 8:55 p.m. on Tuesday, the 19th of April, 2022, and this is file number 247-21001043-PA and 1044-ZC. We've heard all testimony from the applicant. We did not have any in support other than the applicant's team, and no neutral, but we did have opposition testimony. So now is the time in the hearing where I turn it back to the applicant to submit any rebuttal testimony. I do note that there is vacuuming going on out in the hall, so hopefully that's not going to affect the quality of recording here. We're going to get the doors shut. So the applicant has an opportunity for rebuttal, and then staff can make some closing remarks. I will note that there have been a couple of requests to leave the record open, so we will be discussing that after the applicant's rebuttal. All right. So take it away.
All right, again, for the record, Ken Katzeroff, attorney at Schwab Williamson Wyatt for the applicant. I do have rebuttal, but before I do so, we would like to have Brian Raby please be elevated to panelist, and he's going to provide some specific rebuttal to a couple of points regarding soils and water.
Okay.
And I will mute myself for the moment. Thank you.
Thank you.
Good evening, everyone.
Good evening.
Hear me okay? And looks like everything's working okay. Okay, I wanted to just touch on a few things. Been taking a few notes through a variety of the elements of testimony. And I think I'll start with the soils. I had noticed in one of the written submittals a point that I thought found a little confusing, but I'll focus on the oral testimony. The representative from Central Oregon Land Watch had referenced the published soil survey from the NRCS, and that cannot be changed, and that they had walked the land from north to south and east to west. Both of those are patently untrue. The NRCS does not have a "I can trespass on private property" card, and so much of what they did in their mapping effort was without ever setting foot on a majority of the private land in all of their survey areas. Most of that work was done looking at road cuts and other public access points and trying to establish relationships between the features they could see and the aerial photographs that they were working with. And in the old days, it was done with stereo pairs. I'm sure that they've got new methods that they use for their remote sensing and indirect measurements. But again, most of their boundary lines were drawn with remotely sensed data, not with a physical examination of the ground itself across, again, a large swaths of the private land. They needed to seek permission before trespassing on private land to conduct their work. As it relates to the technical bulletin 629, all that merely says is the NRCS will not adjust their published soil survey for any work done by others. The soil survey manual has very specific procedures for conducting other orders, including Order 1 soil surveys, and what those requirements are for things like land use planning, more detailed assessments are necessary. And that, as Ken Katzeroff had mentioned earlier, that is fully established in Oregon law with the procedures outlined by DLCD for the conducting, reporting, review, and submission of Order 1 soil surveys, such as the one I prepared for this property. Again, it was brought up in one of the written submittals that that this should have, in fact, maybe it was done in one of the oral ones as well, that this should have covered the entire property and not just a portion of it. I'm here to tell you, I spent 10 long, full days traipsing across that entire acreage. I walked every single boundary of every delineation that is on the map and the report that we produced. And so, you know, I have become more intimately familiar with that piece of property than probably any other human being walking this earth in that exercise. It is a very thorough and detailed assessment. Another point was made by the Central Oregon Land Watch representative about the rocks having no impact. The rocks by themselves don't always have a direct impact, and whether the rocks are there or not is a very important matter. It's the depth of the soil above the bedrock and the amount of rocks contained both within the soil profile and at the surface that have an impact. So it's the volume of rock that takes away from the volume of soil. In other words, if you have a 20-inch deep soil that's 30% rock, you take the rock out and you only have about 14 inches of soil. It's the soil that holds the moisture, and it's the available water holding capacity or the moisture holding capacity of that soil that is the primary factor in Deschutes County that moves a soil from class 6 to class 7. Because if a soil holds more than 2 inches of water, it's considered a class 6 soil. If it holds less than 2 inches of water, then it's class 7. And class 7, by definition in Oregon statute, is not agricultural land. Another factor that relates to the rocks, because the point was made, I believe, by Mr. Buchanan about being able to do range improvement. And there are certain parts of the property, roughly 29% from my survey, that are class 6 and have little or no rock at the surface where you could do some rangeland improvements. But that is well below the legal requirement of predominance, where 71% of the property is predominantly class 7. And again, even trying to make improvements on the smaller fraction of the property would be very challenging, because you'd have to clear, be able to drill to get some of those various grass varieties to grow. And I think another point was made regarding the rainfall at about 18 inches, and there's not 18 inches of rainfall annually in that area. The closest weather station is in Redmond, and the average rainfall is between 9 and 10 inches per year. And so you have the limitation associated with the ability of the soil to hold the moisture and the ability of the climate to provide the moisture, both of which are necessary to sustain the grazing. So I guess since I've been mixing soils and grazing together, I will go on a bit further as it relates to grazing. I was a little bit surprised when, and again, Ken pointed out that it was a very generous assessment of what you could glean, and I don't have that specific data about the $48,000 per year that could be obtained. I'm not sure how that actually would be. I think that was, a very generous presentation of that potential. Based on the standard grazing for native grasses, where you only harvest about 25% of that biomass and leave the other 75% for wildlife and the ability of the plant to regenerate itself to produce forage next year, in other words, to prevent overgrazing. Even in a favorable year, the NRCS data applying the soils as mapped only came up with 176. It was 99 to 176 AUM. I just earlier today spoke with one of my neighbors. I own 646 acres of timber grazing ground in Eastern Oregon. And I leased that. For the last 15 years, I leased that out to a neighboring rancher. And I just was checking with my neighbor to say, well, what are we charging this year for our per AUM for grazing? And it's a little different. I'm, mixed conifer, but I've got steep rocky stuff just like this site. So not all of my acres produce grass, but And again, we go pretty light. We're only 50 AUM on 646 acres, but we're only going to be charging $14 per AUM. So if we took the 176 AUM that I was saying is the generous end of the spectrum for this property, at $14 an AUM, we're only talking about $2,464 in annual grazing revenue. And that doesn't even come close to covering the property taxes. Even with my forest deferral on my property, the grazing revenue does not cover the property taxes and the fire assessment from Oregon Department of Forestry, which is included in the property taxes. So it's difficult for a producer to invest in things like fencing. This property is partially fenced, but there's well over a mile of its boundary that's not fenced, and much of the rest would need improved. And at $15,000 to $20,000 a mile for fencing, last I recall when we had to have some fencing replaced after a forest fire, you're talking about a substantial investment, and the revenue wouldn't offset a lot of those expenses. And as many have said, that's beyond what a reasonable farmer would be able to do. I mean, farmers are in the business of making money, not going in the red. One last point I guess I'll circle back to is, some issues that were raised about water. And I know, there's others that can address this in more detail based on the report that was produced. But I did want to make one important point, and that is the difference between residential development and agricultural development when it comes to water usage. A residence is limited with an exempt well to irrigating up to a half acre of landscaping and garden and the residential use. The residential use itself is truly non-consumptive because the water that's used in the home goes right back out another pipe through the septic tank into the drain field below the surface of the ground, where it soaks in and completes the water cycle. The half acre of exempt use for lawn and garden on 71, potentially worst case, 71 residences would be less than the equivalent of a 36 acre irrigated field. And so even if water rights could be attained, and I think, that's already been explained, would be a very major challenge. It would be, the impact of this would be even less than, 36 acres, which is a small fraction of this total property. And again, majority of that being class 7 and not suitable for irrigation due to the shallow nature of the soils and the rock, etc. So I believe I've covered all the key points that I wanted to address, and I will turn it back over to Ken.
Thank you, Mr. Robbie.
All right, I will try to keep my comments fairly brief, given that we already it's already 9:10 and we still have to talk about record. But that said, I do have some points of rebuttal that I'd like to make. The first is it's important to note that there are about 29% class 6 soils. We're not disputing that. But they are not contiguous. They're kind of all over the property. And so I just want to be clear, what we're talking about here is 71% non-ag soils, and that's the test. It was articulated very well by Carol that we have a legal test. And the legal test is whether or not we're ag lands, and we're not. And we show that because of the definition of law of soil classifications. So backing up to where I really wanted to start was comments that were made with relation to a couple of overarching issues. The first of which is traffic and safety. And we are certainly concerned for traffic and safety in anything we do with land use planning. But to be clear here, those comments were largely directed to Lower Bridgeway, and that would not be the primary access point for any potential development on this property. Simply would not be. And we have submitted a traffic study that shows that. As a hearings officer also knows, any potential development proposal, if this would be approved, a subdivision application or something of that nature, would come along with it specific requirements for road improvements and traffic safety improvements, et cetera. And so while we certainly understand that change is difficult sometimes and additional traffic on roads can be alarming or seem that way, any actual development of this property would come with offsetting traffic improvements as required under the code. A really, really important point on this particular property is there were a number of comments raised about this being a wildlife sanctuary or a wildlife area. And the fact of the matter is that it is not mapped as such. There is no wildlife overlay zone. There is no Goal 5 resource that is mapped on the property. And so while we may have a difference of opinion of whether or not there's wildlife use, that's kind of irrelevant. The legal standard that must be applied is whether or not it's mapped with the county's Goal 5 wildlife inventory, and it is not. And so it's not really a relevant consideration. It's not applicable criteria to this application. I don't really have a ton to say on water. I think Brian covered it extremely well. One note that I would say is with regards to Ms. Gould's comments, 1-for-1 offset on a groundwater permit. I'm seeing this in a number of my cases right now, and I just want to be clear here. The 1-for-1 offset under the Deschutes Basin program doesn't actually require that you put water, quote, back in the stream. There is a whole long list under the Deschutes Basin rules that effectively does that effectively puts water permanently in stream and legally protects it. But it doesn't actually require what a lot of people think, meaning a transfer of water into the stream or something of that nature. Again, none of this is relevant. I just want to let the hearings officer know that when there's comments about, oh, you have to put things in stream, that's not accurate. There are legal requirements and we meet them, but it's actually not relevant here, so we don't meet them. We don't have a water issue here, I guess is my point. One thing that I need to really hit on is Ms. Gould also kind of cried foul on receiving comments related to the state agency's letter. And I just want to be clear here that the state agency had as much time as everybody else to comment on this application and didn't until today. And we only received those comments because the representative, Angie Brewer, actually emailed them to us at the same time as she did the county. And I'll note that the county immediately put them up onto the record. And so anybody who is reviewing the record in this case, which is what is maintained on Acela, had access to those comments immediately as well. We just happened to read them because we were the applicant and the agency sent them to us. That said, we have had no communication with the agency until now. And as the representative mentioned, I think we are going to simply disagree a little bit on the law here. We have shown that we don't meet the definition of agricultural land. And if you read the subtext of kind of the letter, it's that this property should really just be kept as open space. And that's just not the law. If we don't meet ag lands, then we can use it for something else, and that's what we're requesting to do. There's one point in this letter that I want to specifically mention, and that's a comment related to mitigation and ODF and W. And the fact of the matter is, again, we are not mapped as a Goal 5 resource, number one. And number two, there is a reference here to a no net loss standard. And quite frankly, it's one of the reasons I mentioned the destination resort overlay before, is I think that ODF and W is confusing applicable criteria because there is no net loss standard in the code, except as it relates to the establishment of a destination resort. And so there is no requirement for no net loss of habitat. So it's important because, again, we're not mapped as wildlife as a Goal 5 resource, number one. And number two, the only no net loss standard is with regards to destination resorts, which we're not requesting. So it's really kind of irrelevant. I just want to be clear that there's no net loss standard in the code. Going really quickly, I was a little confused by the representative's comments about needed housing. We certainly haven't asserted that this is needed housing and very much understand that that's an issue inside the urban growth boundaries and not in the county. But I think there was general confusion over a term that was used, affordable housing, earlier. And the applicant did not claim that we would be building potentially affordable housing here. It's just that that's a cause that's near and dear to the applicant's heart, and they would like to support those causes as appropriate. But again, I wasn't sure what the needed housing reference was to, so I just wanted to mention that. Lastly, two more things, sorry. This goes back to the destination resort criteria. And Ms. Macbeth mentioned the statute, ORS 1974551A, that provides criteria. And the only reason I'm saying anything about this is because this is a point of settled law. It has been interpreted by LUBA, Court of Appeals, the Supreme Court, everybody. That criteria that was mentioned has no relation to any destination resort application. It only relates to the county's own mapping process for determining what lands are eligible for destination resorts. This is settled law. And so, again, we are not requesting a destination resort. However, I have to make clear that this law simply doesn't apply, and it wouldn't apply because it's already mapped. Last thing I want to say is that Carol, Ms. Macbeth, I apologize, made a comment that we need to prove that the property can't be used for any farm use. That is not correct. That is not the legal standard. We need to prove that this is not agricultural land. We do not need to prove that there can be no farm use made of the property. That is not the standard. It's sort of corollary in that farm use is whether or not you can have a business primary for obtaining profit. And I think what we have shown tonight, as well as testimony from Mr. Raby and others, is that to have a farm use is going to be near impossible on this property, and we simply don't meet the definition of ag lands. So I'm going to leave it there unless you have any other questions or unless you have any specific information that you would like to be addressed in the future.
No, I do not have any specific questions or follow-up questions. I do appreciate very much everyone's testimony this evening, the submittals into the record that have been made already. And I did have a chance to look at the agency's letter this afternoon as well before the hearing. And so I do appreciate that as well. I think it's time for us to talk about leaving the record open because there have been a couple of requests. And so, as I mentioned at the beginning of the evening tonight, typically what this would look like would be a 777. So 7 days from today, anyone could submit anything new or expound on what has already been offered or rebut what people have heard this evening. But it's kind of a free-for-all, if you will, for the first 7 days. But then following that, if you didn't put anything in that first 7-day period and you think, oh, gosh, I want to put all these photographs in or something else, sort of the waive it or raise it or waive it in the first 7 days. The next 7 days is for rebuttal of what has been put into the record. Nothing new, please. And then the final 7 days is for the applicant to submit final legal argument. They don't also have a chance to submit anything new in that last 7-day period. So looking at my calendar, and again, this is presuming that a 777 is acceptable to everyone. Some people might want to say 1477 or 14147. I'll get to that in a moment if there's a varied request. Looking at my calendar, the first 7-day period would conclude on Tuesday, the 26th of April, and I will have Holly address deadlines as far as when it needs to be at the counter or over email, internet, cloud, what have you. So first 7-day period would potentially end on the 26th. The next 7-day period for rebuttal only would be Tuesday, May 3rd, and then the applicant's final legal argument Tuesday, May 10th. Before I go further and ask Holly to address how to submit, I will ask anyone that's either on Zoom or here in the hearing room tonight if they wanted something other than a request for 777. Okay, so those are the dates that I'm going to go ahead with. So please, if you've got a phone or a calendar or notes, 4/26, for any new evidence, argument, what have you. 5/3, rebuttal. And then applicant, please note 5/10 as final argument. And then I'm going to ask Ms. King to address how to make sure that your submissions get in on time so that they are included.
Thank you, Hearings Officer Marshall. And just for everyone here, for the open record period, all submittals should be addressed to me, Hallie King. I've got my email up here on the screen, hallie.king@deschutes.org. Please note that any email submittals which exceed 20 pages in length, include any color documents or documents which must be printed larger than 8.5 by 11, must also be submitted as a hard copy. Also, I wanted to note the county does not retrieve information from a website link or personal cloud storage device. It is your responsibility to submit all evidence and testimony directly to myself that you would like the hearings officer to consider. And written submittals as well as electronic submittals must be received by 4 p.m. on the date of the deadline. So again, if you're delivering documents in person, you need to deliver them to our public counter by 4 p.m. And then if you are doing it via email, the submittal must be received by our server by 4 p.m. Just a tip, if you are sending large documents or just submitting electronically, try to do it a few minutes before 4 p.m. Just to account for any electronic transmittal timelines. Again, we have to receive the documents by 4 p.m. And I wanted to just show, again, just to reiterate what Hearings Officer Marshall discussed. The dates are listed here for each of the 3 open record periods. Again, the Tuesday, April 26th at 4 p.m. for new evidence and testimony. The rebuttal, Tuesday, May 3rd, ending at 4 p.m. And the final argument for the applicant only, Tuesday, May 10th at 4 p.m. And that concludes my report. Thank
Great. You. Thank you so much. And again, I wanted to thank everyone for attending and presenting your testimony. I will go ahead and say that we're off the record and